Good afternoon, everyone. I hope everyone who is watching us now live are doing great. Welcome to the 2023 PALS Bar Ops Pre-Week Lecture Series, the frequently asked questions or topics on the 8 bar subjects. I am Kyle Roger Agedan, your host for today's session. Before we officially begin the lecture today, allow me to give you a quick summary on what this event is all about. This is the 2023 Bar Operations Pre-Week, a discussion on the frequently asked topic on the 8 bar subjects. This is an exclusive project of the Philippine Association of Law Schools, or PALS, and the Rex Education. We have been conducting the pre-week lectures in the past few days or weeks, so if ever you have missed some of our previous lectures, you may go to the official Facebook pages of the Philippine Association of Law Schools, or PALS, and Rex Education to view all the previous lectures. Also, we would like to encourage everyone to kindly please like, subscribe, and follow the Facebook pages of PALS and Rex Education so you can be updated on the upcoming discussions and programs. Just a few important reminders on the house rules during our lectures. During this 3-hour lecture today, recording or reproducing our discussions and lectures for any personal gains are strictly prohibited. All video lecture series and discussions are available and can be replayed anytime through the Facebook pages of the Philippine Association of Law Schools and Rex Education. Furthermore, if you have questions in mind during the lecture series, feel free to send it through our Facebook live comment section, and we will be entertaining them at the end of our discussion during our Q&A portion. Having said all this, now allow me to introduce to all of you our speaker for today's pre-week lecture on remedial law focusing on evidence. Our speaker is the founder of Mawis Law Office. She is also a columnist in the Philippine Daily Inquirer and a member of the Technical Working Group for the Code of Professional Responsibility and Accountability on the revision of the Rules of Court, a former member of the Technical Working Group for the Judicial Integrity Board, and a subject matter expert on IDLO DOJ project on the prosecution of crimes involving women and children. She is also an MCLE resource person and the co-author of books on persons and family relations and jitter notes on remedial law. She is a professional lecturer and a member of the Civil Law Department of Philippine Judicial Academy and a professor of law on the following universities: Lyceum of the Philippines University, University of the Philippines, University of Santo Tomas, De La Salle University, University of Makati, and Adamson University. She is currently the Dean of the College of Law of Lyceum of the Philippines University, both Makati and the Cavite campuses. Ladies and gentlemen, please welcome our lecturer this afternoon, Dean Maria Soledad Deriquito, Mawis. Good afternoon, Dean.
Magandang hapon po sa inyong lahat at maraming pong salamat. Magandang hapon. Siguro simulan na natin dahil marami tayong tatalakayin ngayong araw na to. So I was tasked to discuss with you, pre-week notes on evidence. So let me start with the basic. What is evidence? Is proof the same as evidence? No, because it is merely the probative effect of evidence and is the conviction or persuasion of the mind resulting from the consideration of the evidence. Who bears the burden to prove? The burden of proof rests upon the party who, as determined by the pleadings or the nature of the case, asserts an affirmative issue. Contentions must be proved by competent evidence, and reliance must be had on the strength of the party's own evidence and not upon the weakness of the opponent's defense. Now, what is the difference or basic difference between factum probans and factum probandum? Factum probandum refers to the ultimate fact which you want to prove or the proposition to be established, that which a party wants to prove to the court. Example, you want to prove the guilt or innocence of the accused. You want to prove the existence of a breach of contract, the existence of an obligation, the fact of payment, or the injury or damage incurred. And factum probans, on the other hand, refers to the evidentiary facts by which
Hello,
the
Dean.
factum probandum, yes?
Dean, sorry to cut you po. You may now share the slides po.
Wait, just give me a minute because I thought I was sharing already. Sorry.
Sige po, no problem.
Nandito na tayo. Okay. Yan. Okay, can you see it now?
Yes, Dean.
Okay, teka ha. Para mas lumaki. Yan. Okay, mabalik tayo ulit para masundan natin, no? What's the difference between factum probans and factum probandum? Factum probandum refers to the ultimate fact to be proven or the proposition to be established. That which a party wants to prove to the court. Example, you want to prove the guilt or innocence of the accused. You want to prove the existence of a breach of contract. You want to prove the existence of an obligation. You want to prove the fact of payment or the injury or damage incurred. On the other hand, factum probans refers to the evidentiary facts by which the factum probandum will be proved. Example, okay, you want to prove breach of contract. Then your factum probans will be the written contract. Or in cases of collection, no, you want to prove breach, for example, you want to collect the promissory note, okay, will be your factum probans to prove the existence of an unpaid debt. So when is evidence admissible? If there is one thing na dapat memoryahin natin, when is evidence admissible? Okay, dalawang bagay. Evidence is admissible when it is relevant. That is number one. Relevant to the issue. And number two, it is not excluded by the law or these rules. For evidence to be inadmissible, there should be a law or rule which forbids its reception. If there is no such law or rule, the evidence must be admitted subject only to the evidentiary weight that will be accorded it by the court. So ngayon pa lang, miski inadmit yung ebidensya, hindi ibig sabihin matimbang ang ebidensya because weight is different from admission. Now, when is evidence relevant? Evidence is relevant if it has a relation to the fact in issue as to induce belief of its existence or non-existence. The relevancy of evidence is determined by the rules of logic and human experience. Dapat may kaugnayan. Okay, now. And when is evidence competent? Evidence is competent when not excluded by the law or by the rules of court. It is determined by the prevailing exclusionary rules on evidence. The weight, as I said, is different from admissibility. The weight, however, of admissible evidence depends on judicial evaluation. Okay. So pag ang tanong sa bar is the evidence admissible, immediately 2 points. Relevant, and then argue also on the competency. Okay. Whether the evidence is competent or not. Now, when do you object? Admissibility should be objected to at the time the evidence is offered to the court or as soon as thereafter, as the objection to its admissibility shall have become apparent. Objection, for example, to the qualification of the witness should be made at the time such person is called to the witness stand. On the other hand, objection to the testimony should be made at the time the question is asked or after the answer is given when the objectionable features become apparent by reason of the answer. Ngayon, paano kung judicial affidavit ang sinubmit in lieu of direct testimony in open court? Kailan ka mag-o-object? Okay, of course, the witness will be asked to give his personal circumstances. And then the proponent, okay, will now state before the court the purposes for which the direct testimony is being offered. Now, it is after that that the court will ask you any comment. Then that's the time you can object to the purpose or you can object to the questions or answers propounded as stated in the judicial affidavit. Now, because if you don't object, it is very possible that it will be considered by the court as waived. How about documentary evidence? You submit your objection, okay, at the time the proponent formally offers his documentary or object evidence, then that's the time you make your objection. If the objection is not done within such time, the right to object is deemed waived. Okay. Now, what is substantial evidence? Substantial evidence has been defined to be such relevant evidence as a reasonable mind might accept as adequate to support a conclusion, and its absence is not shown by stressing that there is contrary evidence on record, direct or circumstantial, for the appellate court cannot substitute in its own judgment or criteria for that of the trial court in determining wherein lies the weight of evidence or what evidence is entitled to believe. On the other hand, ano naman yung ibig sabihin ng preponderance of evidence? Preponderance of evidence is the weight, the credit, the value of the aggregate evidence, the totality of evidence on either side, and is usually considered to be synonymous with the term greater weight of evidence or greater weight of credible evidence. It is not therefore paramihan, okay? Preponderance of evidence is a phrase that in the last analysis means probability of the truth. It is evidence that is more convincing to the court as it is worthier of belief than that which is offered in opposition thereto. Now, what is clear and convincing evidence? Yan ay mas mataas ang antas sa preponderance of evidence. And as defined in the case of Andaltan, this is the quantum of evidence that requires more than preponderant evidence, but less than proof beyond reasonable doubt. And might as well, since I discussed the case of Andaltan, pagdating daw sa Article 36 cases, okay, psychological incapacity cases, even if it is a civil case, the degree or the quantum of evidence required for the court to be able to declare the marriage null and void on the ground of Article 36 is clear and convincing evidence. Okay. Now, what is proof beyond reasonable doubt? Proof beyond reasonable doubt is the degree of proof that after investigation of the whole record produces moral certainty in an unprejudiced mind of the accused's culpability. Such moral certainty is, however, lacking in the case of Atienza versus People due to the insufficiency of the circumstantial evidence. Now, can the admissibility of evidence be passed upon during preliminary investigation pa lamang? Well, according to the case of Massa versus Turla, the answer is no. A preliminary investigation is merely preparatory to a trial. It is not trial on the merits, since it cannot be expected that upon the filing of the information in court, the prosecutor would have already presented all the evidence necessary to secure a conviction of the accused. The admissibility or inadmissibility of evidence cannot be ruled upon in a preliminary investigation. In fact, in one of the cases decided by the Supreme Court, hearsay evidence is allowed, okay? Dapat i-consider daw yan ng public prosecutor for purposes of preliminary investigation. Now, kanina nabanggit ko, number one, kailangang relevant, may kaugnayan sa fact in issue. The second is competent. At ang competent, hindi siya excluded by the rules. What are our exclusionary rules? Number one source is the Constitution. First, Section 2 and Article 3 of Sections 2 and 3 of Article 3 of the 1987 Constitution provides the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no such warrant or warrant of arrest shall issue, except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. Now, Section 3 further provides the privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. So any evidence obtained in violation of the two sections shall be inadmissible for any purpose in any proceeding. So it's very clear from the Constitution, hindi tatanggapin yan if the said evidence was obtained in violation of Sections 2 and 3. Now, Also under Article 3, Section 12, okay? Any person under investigation for the commission of an offense shall have a right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. If the person cannot afford the services of counsel, he must be provided with one. And these rights cannot be waived except in writing and in the presence of counsel. Nor torture, force, violence, threat, intimidation, nor any other means which reshape the free will shall be used against him. Secret detention, places, solitary, incommunicado, or other similar forms of detention are prohibited. Any confession or admission obtained in violation of this constitutional provision shall be inadmissible in evidence against him. And the law shall provide for penal and civil sanctions for violation of the section, as well as compensation and rehabilitation for the survivors. Okay, now also under Article 17, no person shall be compelled to be a witness against himself. Kaya pag tinanong sa bar, no, is the evidence admissible? Please answer first the matter of relevancy. Then second, think deep. Is there any provision or law that prohibits, okay, the admissibility of this document? Because you now have to discuss the aspect of the evidence being competent. Now, let me now refer you to the case of People versus Cugain. As a general rule, searches conducted with a warrant that meets all the requirements of Article 3, Section 2 of the 1987 Constitution are reasonable. This warrant requires the existence of probable cause that can only be determined by a judge. However, there are instances when searches are reasonable even when warrantless. And based on jurisprudence, these are warrantless search incidental to a lawful arrest, seizure of evidence in plain view, search of a moving vehicle, consented warrantless search, custom search, stop and freeze, and exigent and emergency circumstances. The search involved in this particular case was initially a stop and frisk search, but it did not comply with the requirements of reasonability required by the Constitution. Because in this case, you know, the police receive a tip or somebody's aboard the jeep and he's carrying, you know, a duffel bag full of marijuana. So they set up this checkpoint, no? And the driver went down and told the police, sabi ng driver, mukha yung pasahero ko, mukhang may dala. Okay. And based on what was shared to him by the, by the driver, jeepney driver, the police approached the accused and asked the accused to open his bag. And he opened his bag. And lo and behold, there were, you know, bricks of marijuana. Now, stop and freeze searches, sometimes referred to as Terry searches, are necessary for law enforcement, according to the Supreme Court. That is, law enforcers should be given the legal arsenal to prevent the commission of offenses. However, this should be balanced with the need to protect the privacy of citizens in accordance with the Constitution. The balance lies in the concept of suspiciousness, present in the situation where the police officer finds himself or herself in. This may be undoubtedly based on the experience of the police officer. It does not have to be probable cause, but it cannot be mere suspicion. It has to be a genuine reason to serve the purposes of the stop and freeze exception. The stop and search was originally limited to outer clothing and for the purpose of detecting dangerous weapons. Now, in the case of Cugain, there was not a single suspicious circumstance in this case, as there was no approximation of the probable cause requirement for warrantless arrest. Cugain was simply a passenger carrying a bag and traveling aboard a jeepney. He was not even the person mentioned by the informant. The informant gave the name Marvin Buya, and the person searched was Victor Cugain. If it was true that Cugain responded by saying that he was transporting the bag to Marvin Ibuya, this still remained only as one circumstance. This should not have been enough to see that Cugain and his belongings without a valid search warrant. Likewise, the facts of the case do not qualify as a search incidental to a lawful arrest. the apprehension of Cogayed was not effected with a warrant of arrest. None of the circumstances mentioned in Rule 113, Section 5 of the Rules of Court were present when the arrest was made. At the time of the apprehension, Cogayed has not committed, was not committing, or was about to commit a crime. There were no overt acts within plain view of the police officers to suggest that Cogayed was in possession of the drugs at the time. Also, Cogayed was not an escaped prisoner that time. Hence, he could not have qualified for the last allowable warrant of arrest. Notice that it was the jeepney driver who had to point to Cogayed. He would not have been identified by the police officers otherwise. It is the police officers who should have observed observed facts that would lead to a reasonable degree of suspicion of a person. Ang nag-entertain ng suspicion yung driver. It was not the police officer. The police officer, therefore, should not adopt the suspicion initiated by another person. So there can be no valid waiver of Cogayed's constitutional rights, even if we are to assume that he did not object when the police asked him to open his bags. Appellant's silence should not be taken lightly as consent to such search. The implied acquiescence to the search, if there was any, could not have been more than a mere passive conformity given the intimidating circumstances during that time. So it cannot be said that the implied consent, falls within the purview of the constitutional guarantee. Now, in the case of Ambre versus People, in arrest in flagrante delicto, the accused is apprehended at the very moment he is committing or attempting to commit or has just committed an offense in the presence of the arresting officer. Clearly, to constitute a valid in flagrante delicto arrest, two requisites must concur. First, the person to be arrested must execute an overt act indicating that he has just committed, is actually committing, or is attempting to commit a crime. And number two, such overt act is done in the presence or within the view of the arresting officer. Ambre is deemed to have waived her objections to her arrest for not raising them even before entering his plea. Now, in the case of Veridiano versus People, again, relying on Section 5 in this case of criminal procedure, these are the instances when arrest, even without a warrant, may be lawful. That will be Section 5, A, B, and C. Now, the first kind of warrantless arrest is what is referred to as flagrante delicto. The validity of this warrantless arrest requires compliance with the overt act test as explained in Cogayed. What is this overt act test? For a warrantless arrest of in flagrante delicto to be effected, two elements must concur. Number one, the person to be arrested must execute an overt act indicating that he or she has just committed, is actually committing, or is attempting to commit a crime, and such overt act is done in the presence or within the view of the arresting officer. Failure to comply with the overt act test renders an in flagrante delicto constitutionally infirm. In Cogayed, the warrantless arrest was invalidated as an in flagrante delicto arrest because the accused did not exhibit an overt act within the view of the police officers, suggesting that he was in possession of illegal drugs at the time he was apprehended. Now, Section 113, Section 5B of the Rules of Court pertains to a hot pursuit arrest. The rule requires that an offense has just been committed. It connotes immediacy in point in time. So, that a crime was in fact committed does not automatically bring the case under this rule. An arrest under Rule 113, Section 5B of the Rules of Court entails a time element from the moment the crime was committed up to the point of the arrest. In this case, petitioner's arrest again could not be justified as an in flagrante delicto arrest under Rule 113, Section 5A of the Rules of Court. He was not committing a crime at the checkpoint petition, and this is the Cogayed case, no? He was also, again, he was just merely a passenger who did not exhibit any unusual conduct. Okay. And the reliable information alone is insufficient because the information came from the driver and not even from the police. The warrantless arrest cannot be justified as the police officers had no personal knowledge of the fact or circumstances indicating that petitioner was committing a crime. Okay. Another statutory exclusion is RA 1405, or otherwise known as an act prohibiting disclosure of or inquiry into deposits with any banking institution and providing penalty therefore. So under RA 1405, all deposits of whatever nature with banks or banking institution in the Philippines, including investments in bonds issued by the government of Philippines, its political divisions, its instrumentalities are hereby considered as absolutely confidential in nature and may not be examined, inquired, or looked into by any person, government official, bureau, or office, except, number one, upon written permission of the depositor. Second exception, in cases of impeachment. Third, upon order of a competent court in cases of bribery or dereliction of duty or of public officials. And number four, where the money deposited or investment is the subject matter of the litigation. Okay. Now we also have RA 6426. And this is an act instituting a foreign currency deposit system in the Philippines. Kung yung RA 1405 ay lahat ng mga deposito, itong 6426 is specific only to foreign currency. Okay. So all foreign currency deposits authorized under RA 26 rather, as well as foreign currency deposits authorized under PD number 1034 are hereby declared as and considered of an absolutely confidential nature, and except upon the written permission of the depositor, in no instance shall foreign currency deposits be examined, inquired, or looked into by any person, government official, bureau, or office, whether judicial or administrative or legislative, or any other entity, whether private or public. Okay, provided, however, that said foreign currency deposit shall be exempt from attachment, garnishment, or any other or order or process of the court, legislative body, government agency, or any administrative body whatsoever. Now, in the case of GSIS versus CA, and this involves RA 6426, the Supreme Court has ruled that under RA 6426, there is only one single exception to the secrecy of foreign currency deposits. Unlike yung domestic, no? Sa domestic, apat. Ito, isa lamang. And the only exception is the disclosure is allowed only upon the written permission of the depositor. The next exclusionary rule is the anti-wiretapping law. Any communication or spoken word or the existence, content, substance, or purport, effect, or meaning of the same, or any part thereof, or any information therein contained or secured by any person in violation of the sections of the anti-wiretapping law shall be inadmissible in evidence in any judicial, quasi-judicial, legislative, or administrative hearing or investigation. Okay. Now, in the case of Ganaan versus IAC, an extension telephone cannot be placed in the same category as a dictaphone, dictagraph, or any other devices enumerated under Section 1 of RA 4200, as the use thereof cannot be considered as tapping the wire or a cable of a telephone line. The telephone extension in this case was not installed for that purpose. It just happened to be there for the ordinary office use. Now, let's focus now on another topic, and that is judicial notice. What is judicial notice? Judicial notice is the cognizance of certain facts which judges may properly take and act on without proof because they already know them. Now, under the amended rules, there are facts of courts. There are facts which courts must now take judicial notice and of which they may take judicial notice. So may mandatory, may discretionary judicial notice. So judicial notice is based on consideration of expediency and convenience. It displaces evidence since it is already equivalent to proof. It fulfills the object which the evidence is intended to achieve, and therefore makes such evidence unnecessary. In other words, when the court takes judicial notice of this fact, you don't have to prove that fact anymore. Now, the power to take judicial notice must be exercised with caution, and every reasonable doubt, according to the case of Republic versus CA on the subject matter, must be resolved in the negative. Okay. While courts of justice are required to take judicial notice of laws, the rule with respect to ordinances is different. Municipal trial courts are required to take judicial notice of the ordinances of the municipality or city where they sit. However, in the case of RTCs, they must take judicial notice only, number one, when required to do so by the statute, for example, the statute of the City Charter of Manila. And then number two, in case of appeal before them, wherein the inferior court took judicial notice of an ordinance involved in the said case. So the appellate courts may also take judicial notice of municipal or city ordinances, not only where the lower courts took judicial notice thereof, but because there are facts capable of questionable demonstration. For the same reason, courts may take judicial notice of administrative regulations. Now, can the court take judicial notice of court decisions? Courts are required to take judicial notice of decisions of the appellate courts, but not the decisions of coordinate trial courts, nor even of a decision or facts involved in another case tried by the same court itself, unless the parties introduce the same in evidence or where the court, as a matter of convenience, may decide to do so. Okay. Judicial knowledge is not the same as personal knowledge. Okay. Judicial notice which the court is required to take should not be confused with the personal knowledge of the judge. A fact may be of judicial knowledge and not of the judge's personal knowledge, and vice versa, as this rule refers to facts which ought to be known to judges because of their judicial functions. Now, the question as to what are the laws of a foreign state is one of fact. Diba? Sa civil law, when you talk about foreign law, you must prove it as a matter of fact. And foreign laws may not be taken judicial notice of and have to be proved like any other fact, except where said laws are within the actual knowledge of the court, such as when they are well known and generally known, or they have been actually ruled upon in other cases before it, and none of the parties claim otherwise. To prove a written foreign law, the requirements of sections 24 and 25 must be complied with. That is by official publication or by duly attested or authenticated copy thereof. The provisions of foreign law may also be subject to judicial admissions. Absent any of the foregoing evidence or admission, processual presumption will kick in. And what is that doctrine of processual presumption? The foreign law is presumed to be the same as that in the Philippines. Okay. Now, what are judicial admissions? Iba yung judicial admissions sa judicial notice. Ang judicial admissions naman po, judicial admissions may be made in the pleadings filed by the parties, in the course of the trial by verbal or written manifestations or stipulations, or third, in other stages of judicial proceeding as in the pre-trial of the case. Admissions obtained through depositions, written interrogatories, or requests for admission are also considered as judicial admission. Now, to be considered as a judicial admission, the same must be made in the same case in which it is offered. If made in another case or in another court, the fact of such admission must be proved as in the case of any other fact, although if it was made in a judicial proceeding, of course, it will be entitled to a greater weight. Now, what is the rule on judicial admissions made in another case? Judicial admissions made in one case are admissible at the trial of another case, provided they are proved and are pertinent to the issue involved in the latter case, unless the said admissions were made only for the purpose of the first case, as in the rule on implied admissions and their effects, or that the same were withdrawn with the permission of the court therein, or the court deems it proper to relieve the party therefrom. Okay. Now, what are the exceptions to judicial admissions? You know, a statement cannot be considered as a judicial admission if it was made through palpable mistake. or if in fact no such admission was made, or in case of pretrial admission in civil cases to prevent manifest injustice. Now, the same rule applies to criminal cases if the pretrial admission was reduced in writing and signed by the accused and his counsel. Now, in the case of Tagbuena versus CA, the general rule, according to the Supreme Court, is courts are not authorized to take judicial notice in the adjudication of cases pending before them of the contents of the records and other cases, even when such cases have been tried or are pending in the same court, and notwithstanding the fact that both may have been heard or actually pending before the same judge. That's the general rule. And what is the exception to the general rule? In the absence of objection and a matter of convenience to all the parties, the court may properly treat all or any part of the original record of a case filed in its archives as read into the records already of a case pending before it, with the knowledge of the opposing party, and reference is made to it for that purpose by name and number or in some other manner by which it is sufficiently designated, or when the original record of the former case or any part of it is actually withdrawn from the archives at the court's discretion at the request and consent of the parties and admitted as part of the record of the case then pending. Okay. As I mentioned earlier, Philippine courts cannot take judicial notice of foreign laws. They must be alleged in your pleading and may be proved and must be proved as of any other fact. Now, our courts therefore do not take judicial notice of foreign judgments and laws. Philippine courts, to recognize a foreign judgment relating to the status of marriage, the foreign judgment and its authenticity must be proven as facts under our rules of evidence. Okay, now, what are the matters of judicial notice and what are the three material requisites for you to be able to exercise judicial notice? The matter must be one of common or general knowledge. Number two, it must be well and authoritatively settled and not doubtful or uncertain. And third, it must be known to be within the limits of the jurisdiction of the court. Itong kaso ni Atienza versus Board of Medicine, maganda itong kasong to kasi what was presented was a mere photocopy of the X-ray. Okay. Of course, it was being objected to because hindi daw yun yung original. Anong sabi ng Supreme Court? The fact sought to be established by the admission of Editha's exhibit that her kidneys were both in the proper anatomical locations at the time of her operation. In fact, it need not be proved as it is covered by mandatory judicial notice. Alam kasi naman natin na ang kidney wala naman dito sa taas ng ating utak. Ang kidney ay dun sa talagang kung saan siya dapat nakalagay. So in this case, we may take judicial notice that Editha's kidneys before and at the time of her operation, as with most human beings, were in their proper anatomical locations. Now, judicial admissions made by the parties in the pleadings or in the course of the trial or other proceedings in the same case are conclusive. Hence, they do not require further evidence to prove them, as held in the case of PLDT versus Pingol. In fact, if the original complaint, okay, if I refer you back to Rule 10, of the rules on civil procedure, yung bang amendments. Let's say you filed an original complaint later on, okay, you ask the court to allow you to file an amended complaint, okay, because an answer has been filed. So you have to file by way of motion. If no answer has been filed, then you can do it as a matter of right. So you filed an amended complaint. Now, wala na bang saysay yung original complaint? May saysay pa rin yan. The original complaint, in fact, you can use it in evidence. But in order for you to be able to, remember, once the original complaint has been amended, it should no longer form part of the records of the case, no? Wala na siyang saysay. But you can still use that as evidence. So the original complaint must be offered in evidence and accepted when there is an amended complaint filed which lacks statements from the original in order that the statements contained in the original to be considered as judicial admissions and thus binding. Okay, now, can we just have a 3-minute break, no? Siguro every Nakakahinga lang. 3 minutes. Sir, can we just have a 3-minute break?
Noted din.
3 minutes lang. It is 34 minutes of the 37th. I'll come back.
Alright.
Now, under Section 2, yan, ito, medyo madaming amendments dito, no? Documentary evidence, documents as evidence consists of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expression offered as proof of their contents. Photographs include still pictures, drawings, stored images, X-ray films, motion pictures, or videos. Okay. Now, the expanded definition of documentary evidence was taken from the Federal Rules of Evidence of the United States. And it is intended to embrace in the broadest possible terms essentially every memorial that preserves written and spoken language, including recorded sounds. Hence, the inclusion of recordings and sounds in the definition of documentary evidence. The provision of that photographs shall include pictures, stored images, X-ray films, videotapes, and motion pictures should be construed or taken as merely exemplary or by way of examples rather than exclusive in order to embrace similar technology and processes that may be developed in the future. Now, in one case, in the case of Season versus People, okay, and in a more recent case, College Assurance Plan versus Belfront Development and People versus SETA, the court allowed the use of photographs as documentary evidence if they are relevant to the issue and are verified. Verification, okay, the identification and authentication need not be made by the photographer himself. It can be made by any other competent witness who can testify as to its exactness and accuracy. Yung taong kinuha ng picture, pwede siya rin magtestigo nun. Now, the committee opted to use the word videos rather than videotapes as the former is the more modern term and included drawings, okay, pursuant to an American case, no? Were writings within the meaning of the best evidence rule. Now, what is object evidence? Object evidence are those addressed to the senses of the court. When an object is relevant to the fact in issue, it may be exhibited to, examined, or viewed by the court. In the case of Republic versus Jimenez, when a document is presented merely to prove its existence, na ito'y nag-i-exist lamang or condition, it is offered not as document, it is offered therefore as real evidence or object evidence. Kung ang dokumento, okay, inahain mo, you're offering it to prove na ito, may dokumento akong natanggap. Hindi yung laman. Na bilang patunay lamang na ang dokumentong ito ay natanggap ko. Yan ay object evidence. Hindi yan documentary evidence. Okay, now, what are the requirements for an ocular inspection? An ocular inspection conducted by the judge without notice toward the presence of the parties is invalid, as an ocular inspection is part of the trial. Whether an ocular inspection is to be conducted lies in the discretion of the court. Now, when can the court refuse to grant, okay, or allow introduction of object real evidence? When the exhibition of such object is contrary to public policy, morals, or decency. Number two, when to require its being viewed in court or in an ocular inspection would result in inconvenience, unnecessary expense out of proportion to the evidentiary value of such object. When such object or real evidence would be confusing or misleading, as when the purpose is to prove the former condition of the object and there is no preliminary showing that there has been no substantial change in said condition, or that the testimonial or documentary evidence already presented clearly portrays the object in question as to render a view unnecessary. Now, in the case of People versus Alibudbud, it's a 2020 case. Under Section 5 of Article 2 of RA 9165 or illegal sale of prohibited drugs, in order to be convicted of the said violation, the following must concur: the identity of the buyer and the seller, the object of the sale and its consideration, and of course, the delivery of the thing sold and the payment therefore. In illegal sale of dangerous drugs, it is necessary that the sale okay, transaction must actually happen, and that the procured object is properly presented as evidence in court and is shown to be the same drugs seized from the accused. Also, under Section 11, Article 2 of RA 9165, or illegal possession of dangerous drugs, the following must be proven before the accused can be convicted. Number one, the accused was in possession of the dangerous drugs. Number two, such possession was not authorized by law. And third, the accused was freely and consciously aware of being in possession of the dangerous drugs. Okay. Okay. The essential links that must be proven by the prosecution is to establish an unbroken chain of custody over the drugs seized in a buy-buy situation are as follows. Apat, para ma-prove mo yung chain of custody. Remember, this chain of custody is a method of authentication. So you have to, okay, memorize this for, okay, to be able to answer whether the seized drugs, for example, should be admissible in court. The first, the seizure and marking, if practicable, of the illegal drug recovered from the accused by the apprehending officer. Number two, the turnover of the illegal drug seized by the apprehending officer to the investigating officer. Third, the turnover by the investigating officer of the illegal drug to the forensic chemist for laboratory and examination. And fourth, the turnover and submission of the marked illegal drug seized by the forensic chemist to the court. So as long as the integrity and evidentiary value of an illegal drug were not compromised, non-compliance with RA 9165 and its IRR may be excused. As sufficiently shown by the prosecution's evidence, Buesa was clearly identified as the person who sold and possessed the illegal substances during the conduct of the buy-bust operation. As soon as the sale was consummated and the body of Buesa was frisked, PO2 Abad arrested Buesa and marked the seized items immediately at the place of arrest. Subsequently, due to the fact that the place of arrest was accident-prone, so the police officers brought Buesa and the seized items to the police station to conduct the inventory and taking of photographs in the presence of the witnesses required by law. Then the seized items were brought to the crime lab where they tested positive for shabu. These are the very same items were duly identified and marked as exhibit in court. Now, in the 2020 case of People versus Del Rosario, it is established rule that an appeal in criminal case throws the whole case open for review. Thus, the appellate court has the competence to examine records, revise the judgment appealed from, increase the penalty, and cite the proper provision of the penal law. After the careful examination, the Supreme Court found the appeal in this case meritorious. Now, to sustain a conviction for the offense of illegal sale or possession of dangerous drugs act under RA 9165, it is of utmost importance to establish with moral certainty the identity of the confiscated drug. So to remove any doubt or uncertainty on the identity and integrity of the seized drug, it must be shown that the substance illegally possessed or sold by the accused is the same substance offered and identified in court. And the requirement is known as the chain of custody rule, which I mentioned earlier is a form of authentication. And it was created to safeguard doubts concerning the identity of the seized drugs. Okay. Chain of custody means the duly recorded, authorized movements and custody of the seized drugs at each stage from the moment of the confiscation to the receipt in the forensic laboratory for examination until it is presented in court. Dapat ma-explain mo yan. Because the objective is to show that what was seized is the very same item that was brought to court. So under Section 21 of Article 2 of RA 9165, the apprehending team shall have initial custody and control of the drugs, shall immediately upon seizure and confiscation, physically inventory and photograph the same in the presence of the accused or the persons from whom such items were confiscated or seized, or his or her representative or counsel. and any selected and representative from the media in the Department of Justice, and any elected public official who shall be required to sign the copies of the inventory and be given a copy thereof. And the implementing rules and regulations of RA number 9165 further provides the apprehending officer team having initial custody and control of the drugs shall immediately, okay, as I said, after seizure and confiscation, physically inventory and photograph the same in the presence of the accused, the persons from whom such items were confiscated, the representative of his or his counsel, representative from media or the Department of Justice, and any elected officials who shall be required to sign the copies of the inventory and be given a copy thereof. Provided that the physical inventory and photograph shall be conducted at the place where the search warrant is served, or at the nearest police station, or at the nearest office of the apprehending officer team, whichever is practical in case of warrantless seizures. So sinis mo yun, hindi mo pwedeng markahan yan bukas. Meron ka ng doubt dyan. Provided further that non-compliance with these requirements under justifiable grounds. So you can depart a bit, but there should be justifiable grounds to justify the departure, no? As long as the integrity and the evidentiary value of the seized items are properly preserved by the apprehending officer team, shall not render void and invalid such seizures of and custody over said items. So Section 21 of RA 9165 requires the apprehending team after seizure and confiscation to immediately conduct physical inventory of and photograph the seized drugs in the presence of the accused or the persons from whom such items were confiscated or seized, or his representative or counsel, the representative from the media, a representative from the DOJ, and an elective public official. And these witnesses, these four witnesses, are required to be present at the time of the apprehension of the accused and must sign all copies of the inventory and obtain a copy thereof. Now, the procedure enshrined in Section 21 is a matter of substantive law and cannot be brushed aside as a simple procedural technicality, or worse, ignored as an impediment to the conviction of illegal drug suspects. In other words, it has to be strictly complied with. Now, in this particular case, okay, the presence of the representatives required by law to witness the apprehension of appellant and the seizure of the illegal drugs were not secured by the bypass team. The witnesses required by law in order to insulate against a police officer practice of planting evidence should be present at or near the time of the apprehension of the accused. And the court held that the time of the warrantless arrest is the point in which the presence of the three witnesses is most needed, as it is their presence at the time of the seizure and confiscation that would belie any doubt as to the source, identity, and integrity of the seized drugs. Okay. Neither can the prosecution rely on the saving clause of Section 21. The saving clause applies only where the prosecution, okay, has recognized the procedural lapses on the part of the police officers or the PDEA agents and thereafter, okay, explained the cited justifiable grounds. Okay, kaya kung nag-depart ka, you have to give a justification. After which the prosecution must show that the integrity and evidentiary value of the seized items have been preserved. And in this case, no justification was shown. How come, the persons required to be present were not at all present? Okay. Are we okay, sir?
Yes, Dean, we can now
Thank you. Okay. Again, sa mga nanonood, pagpasensyahan nyo na kami. Konting technical glitches lamang. Okay. So let me go back. As I mentioned earlier, as a method of authenticating evidence, the chain of custody requires that the admission of an exhibit be preceded by evidence sufficient to support a finding that the matter in question is what the proponent claims to be. Okay? Yun ang pinaka-importante. Okay? Now, it would include testimony about every link in the chain from the moment the item was picked up to the time it is offered into evidence in such a way that every person who touched the exhibit would describe and from whom it was received, how and from whom it was received, where it was and what happened to it while in the witness's possession, the condition it was received and the condition in which it was delivered to the next link in the chain. So every handling yan, i-explain mo yan. These witnesses would then describe the precautions taken to ensure that there have been no change in the condition of the item and no opportunity for someone not in the chain to have possession of the same. And the Supreme Court enumerated the links that the prosecution must establish in the chain of custody of a buy-bust situation to be as follows. First, the seizure and marking, if practicable, of the illegal drug recovered by the accused from the accused by the apprehending officer. Two, the turnover of the illegal drug seized by the apprehending officer to the investigating officer. Third, the turnover by the investigating officer of the illegal drug to the forensic chemist for lab examination. And finally, the turnover and submission of the marked illegal drug seized by the forensic chemist to the court. The court said that the second, the third, and the fourth links in the chain of custody was not established by the prosecution in the case at bar. Okay. Another topic at least, okay? Original document rule. Okay? Now, Section 3 provides original document must be produced, exceptions. When the subject of the inquiry is the contents of a document, the writing, recording, photograph, or the record, no evidence is admissible other than the original document itself, except in the following cases. When the original is lost or destroyed or cannot be produced in court without bad faith on the part of the offerer, or when the original is in the custody or under control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, or the original cannot be obtained by judicial process or procedure, or when the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result of the whole, and when the original is a public record in the custody of a public officer or is recorded in a public office, or when the original is not closely related to the controlling issue. Okay. Now, ano naman ang original document? An original of a document is the document itself or any counterpart intended to have the same effect by a person executing or issuing it. An original of a photograph includes the negative or any print therefrom. If data is stored in the computer or similar device, any printout or other output readable by sight or other means shown to reflect the data accurately is an original. A duplicate is a counterpart produced by the same impression as the original or from the same matrix or by means of photography, including enlargements and miniatures, or by chemical or electronic re-recording, or by chemical reproduction, or by any other equivalent techniques which actually accurately reproduce the original. Okay. So a duplicate is admissible to the same extent as an original. Okay? Pag ang pinisalita mo yung duplicate original, kapantay din yan ang original. Unless a genuine question is raised as to the authenticity of the original, or in the circumstances it is unjust or inequitable to admit a duplicate in lieu of the original. So the term original does not necessarily mean the first writing, recording, or photograph that was made, but rather it refers to the writing or recording or photograph that is at issue in litigation. The determination of whether a writing or recording is an original depends upon what is being offered to prove. With respect to photographs, not only the negative but any printer form qualifies as an original. So as to any output from a computer, the amendment adopts Section 1 of Rule 4 of the Rules on Electronic Evidence, which provides that any printout readable by sight and shown to reflect accurately the data stored in the computer is an original, but is an original only of the data stored in the computer or the diskette. The definition of duplicate, in the amendment was actually adopted again from the Federal Rules on Evidence. The definition makes duplicates generally admissible in lieu of the originals without showing the unavailability of the original. And the amendment defines duplicate to mean a counterpart produced by any reliable modern mechanical process. The rationale behind the new rule is to eliminate the best evidence objections to copies made in clearly reliable ways, except where the objecting party can offer a good reason to support the production of the original as indicated by the new section. Okay. So what is the original document rule? It provides that when the subject of the inquiry is the contents of the document, that's very important. Yung ang pinag-uusapan, ang pinag-aawayan ay yung laman ng dokumento. No evidence shall be admissible other than the original document itself. That's the rule. Except when the original has been lost or destroyed or cannot be produced in court without bad faith on the part of the offerer, or when the original is the custody or under the control of the party against whom the evidence is offered and the latter fails to produce it after reasonable notice. Okay. Or when the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result of the whole. Ang dami mga dokumento, no? Yung pala ang kukunin mo lamang ay yung totality, yung summary, no? Now, the voluminous records, however, must be made accessible to the adverse party so that the correctness of the portion produced or the summary of the document may be tested on cross-examination. Or when the original is a public record or in the custody of a public officer or is recorded in a public office. So where the issue is only as to whether the document was actually executed or whether the document actually exists or the circumstances relevant to or surrounding the execution of the document, the original document rule does not apply and testimonial evidence is admissible. So the original document rule comes into play only when the subject of the inquiry is the contents of the document. Now, what is a documentary evidence? Documents as evidence consist of writings or any material containing letters, words, figures, symbols, or any other modes of expressions, written expressions offered as proof of their contents. And we have already discussed what would be considered as original document, which is the original document is one of the contents of which are the subject of the inquiry. When a document is in 2 or more copies executed at or about the same time with identical contents, including signed carbon copies, all such copies are equally regarded as originals. Or when an entry is repeated in the regular course of business, one being copied from another at or near the time of the transaction, including entries in journals, ledgers, all entries are likewise equally regarded as originals. Now, what is the concept of collateral facts rule? It states that a document or writing which is merely collateral to the issue involved in the case on trial need not be proved. So where the purpose of presenting a document is not to prove its contents, but merely to give coherence to or make intelligible the testimony of the witness regarding a fact contemporaneous to the writing, the original of the document need not be presented. Now, what is the rule on duplicate originals? It states that when a document is in 2 or more copies, executed, itong pinaka-importante ha, executed at or about the same time. Hindi pwedeng kinopya, pina-photocopy mo, 10 years ago naman ang nakaraan, bago mo na 10 years after the original was signed. Hindi siya duplicate original, no? Even if with identical contents. Now, as I said, the duplicate original should be 2 or more copies executed at or about the same time with identical contents. All such copies will now be equally regarded as originals. It may be introduced in evidence without accounting for the non-production of the other copies. Now, in the case of People versus Jimenez, even with respect to documentary evidence, the best evidence rule, which we now refer to as the original document rule, applies only when the content of such document is the subject of the inquiry, where the issue is only as to whether such document was actually executed or exists, or on the circumstances relevant to the execution, to or surrounding its execution. The original document rule does not apply and testimonial evidence is admissible. Now, in the case of Guao versus Chua, where the only issue as to whether such document was actually executed or exists, or on the surrounding relevant to or surrounding its execution, as I said, the original document rule will not apply. Now, in Air France versus Carrascosa, where the object is not the actual entry in a document, but the fact that the entry was made, na sinulat niya, it does not come into play, the original document rule. In Maglasang versus People, 2021 case, pursuant to Section 20 of Rule 132 then, a private document may be authenticated by the person who executed it, the person before whom its execution was acknowledged, any person who was present and saw it executed, the person who after execution saw it and recognized the signature, being familiar thereto or an expert, or the person to whom the parties to the instrument had previously confessed execution thereof. Now, secondary evidence. Okay, this is an exception, of course, to the original document rule because you cannot produce the original. Now, what happens if the original document is unavailable? When the original document has been lost or destroyed or cannot be produced in court, the offerer, upon proof of its execution or existence and the cause of its unavailability, okay, without bad faith on his part, may prove its contents by a copy, okay, or by a recital of its contents in some authentic document, and okay, or by the testimony of witnesses in the order stated. Now, if the document is in the custody or under the control of the adverse party, he or she must have reasonable notice to produce it. If after such notice and after satisfactory proof of its existence, he or she fails to produce the document, secondary evidence may be presented as in the case of loss. Now, summaries. This is a new amendment, no? The contents of voluminous documents, photographs, or numerous accounts, which cannot be conveniently examined in court and the fact sought to be established is only the general result of the whole, may be presented in a form of a chart, summary, or calculation. The original shall be available for examination or copying or both by the adverse party at a reasonable time and place. The court may order that they be produced in court. Evidence admissible when original document is a public record. When the original of document is in the custody of a public officer or is recorded in a public office, its contents may be proved by a certified true copy issued by the public officer in custody thereof. Kasi nga yung original, hindi mo naman pwedeng alisin. Kunwari, birth certificate. Yung original na birth certificate, hindi mo pwedeng kunin o kunwari sa Philippine Statistics Office. So ang iprepresenta mo in lieu thereof will be the certified true copy, and that will be treated as an original. No? Now, a party who calls for the production of a document and inspects the same is not obliged to offer it as evidence. Now, this section 7, with respect to summaries, again, was substantially taken from the Federal Rules on Evidence, but it retains the requirements in the existing rule that the records must be voluminous, that they cannot be examined in court without great loss of time and the facts sought to be established is only the general result of the whole. Since our Supreme Court had already held that in such a case, the original records must be made accessible to the adverse parties so that the correctness of the summary may be tested on cross-examination. E paano kung yung original records hindi ginawang accessible, ay hindi ma-admit yung summary, di ba? Hindi ma-admit yung summary kasi hindi mo binigyan ng kaparapatan yung kabilang party to conduct an intelligent cross, and he needed access to the original record so that he can test the correctness of the summary that was being presented in court. Okay, so what is secondary evidence? Secondary evidence is that which shows the better or primary evidence exists as the proof of the fact in question. It's a class of evidence that is relevant to the fact in issue. It being first shown that the primary evidence of the fact is not obtainable. It performs the same functions as that of primary evidence. All originals must first be accounted for before one can resort to secondary evidence. It must appear that all of them have been lost or destroyed or cannot be produced in court. The non-production of the original document, unless it falls under any of the exceptions, in fact will give rise to the presumption of suppression of evidence. Now, when may secondary evidence be admitted? It may be admitted only by laying the basis for its production, and such requires compliance with the following. Number one, the offeror must prove the due execution and existence of the original document. Number two, the offeror must show the cause of its unavailability. And three, the offeror must show that the unavailability was not due to his bad faith. Accordingly, the correct order of proof, pag secondary evidence, na wala yung original mo, prove the existence of the original, prove the execution of the original, prove the loss of the original, okay, and then you prove the contents. This order, of course, may be changed if necessary at the sound discretion of the court. Intentional destruction of the original by a party who acted in good faith does not preclude the introduction of secondary evidence of the contents thereof. So what is the order of presentation of secondary evidence? Copy of the original, a recital of the contents of the document in some authentic document, or by the testimony of the witness. Now, what is the definite evidentiary rule? Where the law specifically provides for the class and quantum of secondary evidence to establish the contents of a document or bar secondary evidence of a lost document, such requirement is controlling. Example, evidence of a lost notarial will should consist of a testimony of at least 2 credible witnesses who can clearly and distinctly establish its contents. Now, how may the due, di ba, ang sabi natin, prove the execution, the existence, the contents, and the loss. Now, how will you prove the due execution? It may be proved through the testimony of the person who executed it, the person before whom its execution was acknowledged, or any person who was present and saw it executed and delivered, any person who thereafter saw and recognized the signature, one to whom the parties thereto had previously confessed the execution thereof, or by evidence of the genuineness of the signature or handwriting of the maker. And how now do you prove the loss or destruction? It may be proved by a person who knew of such fact, anyone who in the judgment of the court had made sufficient examination in places where the document or papers of similar character are usually kept by the person in whose custody the document was and has been unable to find it, or any person who has made any other investigation which is sufficient to satisfy the court that the document is indeed lost. And now, how do you prove the contents? You can prove it by the testimony now of the person who signed the document, who read the document, or who heard the document being read, or any person who was present when the contents of the document was talked over by the parties to such an extent as to give him reasonably full information of the contents, or any person to whom the parties have stated or confessed the contents thereof. Now, in the case of heirs of Teodoro de la Cruz versus CA, If the party against whom the secondary evidence is offered does not object thereto when the same is offered in evidence, the secondary evidence becomes primary evidence. But even if admitted as primary, its probative value must still meet the various tests by which its reliability is to be determined. Remember, admissibility should not be confused with probative value. Okay. What facts must be shown by the party offering secondary evidence if the original is in the custody of the adverse party? The original is in the possession or control of the opponent. Number two, the demand or notice is made to him by the proponent, signifying that the document is needed. Third, failure or refusal of opponent to produce document in court and satisfactory proof of the existence of the document. And the party, please remember, who called for a document is not obliged to offer it into evidence. Now, what is the form of notice required to be given to the adverse party? No particular form of notice is required. Pwedeng oral, pwedeng written. But of course, the best will always be the written. No? Okay. Now, what is the effect man of refusal or failure of the adverse party to produce the original if justified? It does not give rise to a presumption of suppression of evidence or create an unfavorable inference against it. It only authorizes the presentation of secondary evidence. Now, what are the requisites for the admission of secondary evidence when the original consists of numerous accounts? Number one, the original must consist of numerous or other accounts or other documents. They cannot be examined in court without great loss of time, and the facts sought to be established from them is only the result of the general whole. Secondary evidence may consist of the summary of the voluminous documents or records. Such records must be made accessible to the adverse party so that the correctness of the summary of the voluminous records may be tested on cross-examination. Now, how may be the contents of the document be proved when the original is in the custody of a public officer? Contents may be proved by a certified true copy by the public officer in custody thereof or by official publication. Now, in the case of MMC Industrial Sales versus Sanyong, electronic documents shall be regarded as the equivalent of an original, functional equivalent of an original under the then called best evidence rule, as long as it is a printout or output readable by sight or other means showing to reflect the data accurately. Thus, to be admissible in evidence as an electronic data message or to be admitted as such, okay, then it must comply with the rules on electronic evidence. Okay. Maliksi versus Comelec. The picture images of ballot boxes are electronic documents that are regarded as the equivalents of the original official ballot boxes. The picture images of the ballots as scanned and recorded by the PICOs are likewise official ballots that faithfully capture in electronic form the votes cast by the voter. As such, the printouts thereof are functional equivalent of the paper ballots filled out by the voters and thus may be used for purposes of revision of votes in electoral purpose. The two documents, the official ballot and its picture image, are considered original documents. Simply means that both of them are given equal probative weight. In short, whether either is presented as evidence, one is not considered as weightier than the other. But this juridical reality does not authorize the courts, the Comelec, and the electoral tribunals to quickly and unilaterally resort to printouts of picture images of the ballots in the proceedings without notice to the parties. Despite the equal probative weight accorded to the official ballots and the printouts of their picture images, the rules for the revision of ballots adopted for their respective proceedings still consider the official ballots to be the primary or best evidence of the voter's will. In this regard, the picture images of the ballots are to be used when it is first shown that the official ballots are lost or their integrity has been compromised. Now, in the case of People versus Enojas, here text messages are to be proved by the testimony of a person who was party to the same or who has personal knowledge of them. Kadajas versus People, the 2021 case, Facebook. Are Facebook photos from the Facebook account of the accused admissible in evidence? Kasi ang mga ginamit, alam niyo naman, marami nasisirang pamilya at relasyon dyan sa Facebook na yan. Okay? May nakuhang Facebook posts yung asawa, ginamit na ebidensya laban sa asawa niya. Is it admissible in evidence? Will using them be a violation of one's right to privacy? Okay. Right to privacy is defined as the right to be free from unwarranted exploitation of one's person or from intrusion into one's private activities in such a way as to cause humiliation to a person's ordinary sensibilities. The constitutional right to privacy is meant to protect private individuals from government intrusions. It is not applicable between and amongst private individuals. Here, these Facebook printouts were properly authenticated. Accused did not even say that his account was hacked. He even gave his password to AAA, having given authority to access his Facebook Messenger account. His reasonable expectation of privacy insofar as AAA is concerned had been limited. Thus, there is no right of privacy to speak of. Now, in the case of RCBC versus Oracion, 2019 case. Now, listen carefully because this is a very important case. Now, the Supreme Court did not concede that the pieces of documentary evidence in question are indeed electronic documents, which according to the rules on electronic evidence are considered functional equivalent of paper-based documents and regarded as the equivalent of original under the then best evidence rule if they are printouts or outputs readable by sight or other means shown to reflect the data accurately. For the court to consider electronic evidence as evidence, it must pass the test of admissibility. And according to Section 2, Rule 3 of the Rules on Electronic Evidence, an electronic document is admissible if it complies with the rules on admissibility prescribed by the rules of court and related laws and is authenticated in the manner prescribed by these rules. Now, Rule 5 of the Rules on Electronic Evidence lays down the authentication process of electronic documents. Section 1 of Rule 5 imposes upon the party seeking to introduce an electronic document in any legal proceeding the burden of proving its authenticity in the manner provided. And Section 2 of Rule 5 provides, before any private electronic document offered as authentic is received in evidence, its authenticity must be proved by any of the following means. By evidence that it had been digitally signed by the person purported to have signed it, by evidence that other appropriate security procedure or devices as may be authorized by the Supreme Court or by law for authentication of electronic documents were applied to the document, or by any other evidence showing its integrity and reliability to the satisfaction of the judge. Now, as a method of proof, Section 1, Rule 9 of the Rules on Electronic Evidence provides all matters relating to the admissibility and evidentiary weight of an electronic document may be established by an affidavit stating facts of direct personal knowledge of the affiant or based on authentic records. The affidavit must affirmatively show that the competence of the affiant to testify on the matters contained therein. Evidently, the petitioner in this case could not have complied with the rules on electronic evidence because it failed to authenticate the supposed electronic documents through the required affidavit of evidence. In other words, ang sinasabi ng Supreme Court, may printout ka, hindi ibig sabihin yan automatic tatanggapin ng Supreme Court. Kailangan mo yan i-authenticate. Paano mo ngayon yan ma-authenticate? Sabi ng orasyon, you authenticate it by submitting an affidavit of evidence. As earlier pointed out, what petitioner had in mind at the inception when it filed the complaint was to have the annexes admitted as duplicate originals, as the term is understood in relation to paper-based documents. Thus, the annexes or attachments to the complaint of the petitioner are inadmissible as electronic documents and they cannot be given probative value because there was no affidavit of evidence. Even the section on business records as exception to the hearsay rule of Rule 8 of the electronic evidence requires authentication by the custodian or qualified witness. Okay? A memorandum report, record, or data compilation of acts, events, conditions, opinions, diagnoses made by electronic, optical, or other similar means at or near the time of or from transmission or supply of information by a person with knowledge thereof and kept in the regular course or conduct of business activity, and such was a regular practice to make the memorandum, report, record, or data compilation by electronic, optical, or similar means, all of which are shown by the testimony of the custodian or other qualified witness, is exempted from the rule on hearsay evidence. So in the absence of authentication through the affidavit of the custodian or the qualified person, the said annexes or attachments cannot be admitted and appreciated as business records and exempted from the rule on hearsay evidence. Okay. Now, let me proceed now to Guerrero versus Philippine Phoenix Surety 2020 case. The strength of Phoenix's claim for damages mainly rests on the admissibility and probative value of the police certificate, embodying the contents of the police blotter, and the pictures of the damaged Isuzu vehicle. The lower courts both concluded that the police blotter is an exception to the hearsay rule because it is classified as an entry in official record. A police blotter or certification thereof is admissible in evidence as an exception to the hearsay rule. In order, however, for it to be admissible, the said evidence must be properly presented in evidence. What must have been presented in evidence was either the police blotter itself or a copy thereof certified by the legal keeper. Otherwise stated, the nature of the evidence as admissible, being exception to the hearsay rule, is different from how a party should introduce evidence to make it admissible. The police blotter itself could have been presented to prove the existence of the police blotter, and a copy of the said entry made in order for the opposing party to determine whether the copy is a faithful reproduction of the entry in the police blotter. The party offering the blotter may opt to present secondary evidence in the form of certified copy of the police blotter entry because that is allowed under our rules. Okay. Now, okay. Let's have a 5-minute break, and I will now continue after the 5-minute break a discussion on the parole evidence rule. Okay, just 5 minutes. Okay. Now, let me discuss parole evidence rule. Okay. Sa parole evidence rule, I will not, okay. Sa parole evidence rule, when the terms of an agreement have been reduced in writing. So, do not object and say parole evidence rule kung ang pinag-uusapan natin ay oral agreement, no? Dapat ang terms of the agreement has already been reduced in writing. It is considered as containing all the terms agreed upon, and there can be, as between the parties and their successors in interest, no evidence of such term as other than the contents of the written agreement itself. However, a party may present evidence to modify, explain, or add to the terms of the written agreement if he or she puts it in issue in a verified pleading. So kung may complaint yan, dapat nakalagay sa answer mo. It should have been an issue and it should have been a verified answer. When you talk about an intrinsic ambiguity, mistake, or imperfection in the written agreement, the failure of the written agreement to express a true intent and agreement of the parties thereto, the validity of a written agreement, or the existence of other terms agreed to by the parties or their successory interests after the execution of the written agreement. And the term agreement includes will. So, parole evidence provides that when the terms of an agreement have been reduced in writing, it is considered as containing all the terms agreed upon, and there can be between the parties and their successors in interest no evidence of such terms other than the contents of the written agreement. And what are the exceptions to the parole evidence rule? Okay, there are 3, okay? But please take note that these 4 exceptions must be made an issue in a verified pleading. And what are these 4? Intrinsic ambiguity, mistake, or imperfection in the written agreement, failure of the written agreement to express a true intent and agreement of the parties thereto, the validity of a written agreement, or the existence of other agreement terms agreed upon by the parties or their successor in interest after the execution of the written agreement. Okay, now, what is the requirement in order to modify, explain, or add to the terms of the written agreement if the true intention of the parties to the written agreement? The rule provides that a party may present evidence to modify, explain, or add to the terms of a written agreement if he puts in issue in his verified pleadings the exceptions to the parole evidence rule. And when do you say that the term is ambiguous? When the written contract is so ambiguous or obscure in the terms the party's contractual intention cannot be understood from a mere reading of the agreement. Will the notarization of a simulated written document result to its incontrovertibility? The answer is no. The fact that the question document was reduced to writing and notarized does not accord it the quality of incontrovertibility otherwise provided by the parole evidence rule. How about ambiguity? Ano naman ang ambiguity? The fact that a word or phrase or the general sense of a document or part of it could actually apply to more than one things or event. Diyan may ambiguity. Pero may iba-ibang klaseng ambiguities. Number one is the latent ambiguity. When the writing on its face is clear and unambiguous, but there are collateral matters or circumstances which makes the meaning uncertain or the writing admits of two constructions. Or patent or extrinsic ambiguity. Pagkita mo pa lang, naku, ambiguous na. Where the ambiguity is very apparent on the face of the writing itself and requires something to be added in order to ascertain the meaning of the word. And finally, intermediate ambiguity. When the word in writing are all sensible, have settled meaning, but admit two interpretations according to the subject matter in contemplation of the intent of the parties. Now, how about mistake? An error, it is a blunder. In order that mistake would be an exception to the parole evidence rule, it must comply with the following requisites. The mistake should be one of fact, it must be mutual, and it must be alleged and proved by clear and convincing evidence. Now, what are the distinctions between parole evidence and original document rule? Parole evidence, the original is available in court. Original document rule, the original is not available in court. Parole evidence, it prohibits the varying of the terms of the written agreement. Whereas original document rule, it prohibits the introduction of substitutionary or secondary evidence. Parole evidence controversy is between the parties to the written agreement. The original document rule involves any parties to the action. Now, the parole evidence rule, however, holds true only if there is an allegation that the agreement does not express the intent of the parties. If there is, and this claim, okay, is in issue in the pleadings, okay, the same may be the subject of parole evidence. The rule forbidding the admission of parole or extrinsic evidence to alter, vary, or contradict a written instrument does not apply so as to prohibit the establishment by a parole of an agreement between the parties to in writing entered into subsequent. So meron kang isang dokumento na tapos na, ngayon may pangalawang dokumento nagva-vary, okay lang yon. You can introduce that second document because that was entered into or subsequent, okay, subsequent to the first document. Okay. While parole evidence is admissible in a variety of ways to explain the meaning of written contracts, it cannot serve the purpose of incorporating into a contract additional contemporaneous conditions which are not mentioned at all in writing unless there has been fraud or mistake. When the operation of a contract is made to depend upon the occurrence of an event, which for that reason is a condition precedent, such may be established by parole evidence. This is not varying the terms of the written contract by extrinsic agreement. For the simple reason that there is no contract in existence, there is nothing to which to apply the excluding rule. Now, the purpose of that prohibition is to prevent alteration, change, modification, or contradiction of the terms of the written instrument, admittedly existing by the use of parole evidence, except in those cases mentioned as exceptions. Okay? Now, let me just skip that part, no? For ano na lang yan, para mabasa niyo please. Okay. Now, contracts should be enforced as they are read. If from the words the meaning is plain, the contract should be enforced according to its words. It is to be presumed that persons mean what they say, and interpretation and construction should not be resorted to when the English use is plain. Okay. What is the principle of ambiguity doctrine or contra proferentem rule? The doctrine provides that in the interpretation of documents, ambiguities are to be construed against the drafter. By its very nature, the precept assumes the existence of an ambiguity in the contract. Now, where the terms of a contract prepared by a lawyer of the obligee seems to be vague or ambiguous, the doubt must be resolved against the latter and in accordance with the real intention of the parties. Now, what is the effect of lack of notarization? The absence of the notarization of the deed of sale would not invalidate the transaction evidence therein. It merely reduces the evidentiary value of the document to that of a private document, which now requires proof of its due execution and authenticity to be admissible in evidence. So a defective notarization will strip the document of its public character and reduce it to a private document. Consequently, where there is a defect in the notarization of a document, the clear and convincing evidentiary standard normally attached to a duly notarized document is dispensed with, and the measure to test the validity of the document is preponderance of evidence. Okay, now, what's the difference between competency of a witness from the credibility of a witness? Competency is the legal fitness or legal capacity of a person to testify as a witness. Competency involves a determination of whether the person offered as a witness has all the qualifications prescribed by law and is not among those disqualified by law or by the rules of evidence. Credibility, on the other hand, goes to the character of the witness to be believable or not. This goes to the truth of the testimony. It includes the ability of the witness to inspire belief or not. Hence, a witness may be competent but not credible. Now, of course, the presumption is always the person is capacitated. No? When a person is offered as a witness, he is presumed to be competent. He who claims otherwise is the burden of proving the existence of for a ground of disqualification. Okay. And how do you question competency? Raise an objection, and the objection must be seasonable. Okay, and it must be raised at the time the person is offered and presented to be as a witness, and before he actually testifies, no, or at the time he is actually testifying. Now, these grounds are not grounds for the disqualification of a person to be a witness. Interest in the outcome in the case, relationship, sex, race, creed, property, or prior conviction. Now, there are two kinds of disqualification pag ang pinag-uusapan natin ay pagtestigo. First is absolute. The person is disqualified from being a witness due to physical or mental cause. Okay? And then partial, the witness is disqualified from testifying only on certain matters but not as to other facts. Now, what is this preliminary examination of a witness or the voir dire examination? The examination conducted by the court on the competency of a witness whenever there is an objection to the competency of a witness, and is usually made before the witness starts with his testimony. Kadalasan to nangyayari sa child witness rule. You know, sa child witness examination, the child is presumed to be competent. But if you feel that the child is not competent, you file a motion so that there can be a preliminary examination to determine whether the child is competent to take the witness stand. Okay. So that is it, no? Every child is presumed to be qualified to be a witness. Substantial doubt exists regarding the ability of the child to perceive, remember, communicate, distinguish truth for falsehood, or appreciate a duty to tell the truth in court. Then the court may conduct a preliminary examination, motu proprio, or upon motion of the party. So a person of feeble mind is still competent to testify as long as she could convey her ideas by words or signs. The allegation of insanity or imbecility can never be presumed. It must be proved. Without positive evidence, the defendant has lost his reason or was demented a few moments prior to or to the preparation of the crime, it will be presumed that he still was in a normal condition. A mental retardate is not automatically disqualified from being a witness. As in this case of other witnesses, acceptance of his testimony depends on the nature and credibility, or otherwise put the quality of his perception and the manner he can make it known to the court. Child is competent, okay, to be a witness. Okay? The requirements that then of a child's competency are capacity of observation, capacity of recollection, capacity of communication. Okay. Okay. Now, disqualification by reason of marriage or marital disqualification rule. During the marriage, the husband or the wife cannot testify for or against the other without the consent of the affected spouse, except in civil case by one against the other, or in a criminal case for a crime committed by one against the other, or the latter's direct descendants or ascendants. So during the marriage, neither spouse, that is the witness spouse, may testify against the other spouse, the party spouse, without the consent of the party spouse. Okay. So what are the requisites for its applicability? One of the spouses is a party to the case, whether the case is civil or criminal, okay, or by himself or with other people. Second, and this is very important, the spouses are validly married. This include voidable marriages as well as those where there is a presumption of a valid marriage in the absence of a marriage contract. Bigamous marriages, common law marriages excluded. The reason behind or purpose behind the marriage is immaterial, as when the marriage was intended precisely to prevent one from testifying. Third, the marriage is subsisting at the time one is called to testify against the other, and that it has not been dissolved by death or by law, and this prohibition, by the way, is not perpetual. The case is not a case between the two of them. The consent of the party spouse has not been obtained nor has been waived, or he has waived the rule in favor of the other party. Okay, so what are the forms of prohibited testimony, or when you can say there's a violation? When the spouse is actually called to testify in court as to be witnesses to facts, or when the witness is asked to submit objects, documents, or other evidence in court, even if not actually called upon to testify, or when a person is presented as a witness and asked to divulge declarations or informations revealed to third person by the spouses, which such declarations or information will affect the liability of the spouse, the party spouse. The revelation, please take note, must be made in confidence. If the declaration was made in the presence or hearing of another person, then there is no violation of the rule. So when can you consider the rule on marital disqualification waived? When the waiver is done expressly, or when the party spouse, consents impliedly, as when the party spouses interposed, no objection to the presentation of the witness spouse, or when the party spouse present his own spouse to be his own witness, or when the party spouse imputes the wrongdoing to the other spouse, then of course the other spouse may testify to rebut the imputation. Now, what are the exceptions when the spouse may testify? In a civil case filed by one against the other, example, legal separation. In a criminal case for a crime committed by one against the other, RA 9262, on violence against women and children. Or the reason for the law has ceased to exist. So where the marital and domestic relations are so strained that there is no more harmony to preserve, and peace and tranquility which may be disturbed, then the harmony and tranquility rule pertaining to marital disqualification rule will no longer apply. Okay. Now, in the case of People versus Castañeda, the better rule is that when an offense directly attacks or directly or vitally impairs the conjugal relation, it comes within the exception to the statute that one shall not be witness against the other except in criminal prosecution for a crime by ones against the other. Okay, and these are the other exceptions. Okay. Now let's talk about disqualification by reason of the death or insanity of the adverse party. Okay. Ito malaki ang pagbabago, yung dead man statute. Basically, walang dead man statute na. Kasi iba na talaga yung rule. At ano yung rule? In an action against an executor or administrator or other representative of a deceased spouse. So X versus administrator or executor of the estate of this deceased person. That is the case, no? And now, there is a claim or demand against the estate of the deceased person or against the estate of the unsound person of unsound mind. So sila yung defendant. Where a party or a signer of a party or a person in whose behalf a case is prosecuted testifies on a matter of fact occurring before the death of the deceased person or before the person becomes of unsound mind. Any statement of the deceased or the person of unsound mind may be received in evidence. Pwede nang tanggapin. If the statement was made upon the personal knowledge of the deceased or person of unsound mind at the time when the matter had been recently perceived by him or her and while he or her recollections was clear. Such statement, however, is inadmissible if, of course, the statement that was made by the person of unsound mind or deceased, okay, indicated lack of trustworthiness. Yun naman ang kumbaga, nagtestigo nga, nagsalita nga siya, pero pwede mong gawin, pakita mo, hindi, incompetent yung sinabi, no? Kasi pwede mo namang i-cross yan. Why? Because Bentham criticized the dead man statute as blind and brainless. Because instead of seeking to avoid injustice to the dead, it may cause injustice to the living. In fact, if a survivor has rendered services, furnished goods, or lent money to a man whom he trusted without an outside witness, or admissible written evidence, he is helpless if the other dies and the representative of his estate declines to pay. So the survivor's mouth may be closed in an action arising from, let's say, a fatal automobile collision or in a suit upon a note which the survivor paid in cash without taking a receipt. The problem is that the survivor's disqualification is more likely to balk the honest rather than the dishonest survivor. So one who would not balk unfortunately would hardly hesitate at suborning a third person who would not be disqualified to swear to a false story. Excuse me. Okay. So now, the present rule, as crafted, it allows the survivor to testify by admitting hearsay evidence of the deceased. Ang kumbaga, the only way you can attack it for it to be not admitted is to show what, as stated by the rules, becomes inadmissible if made under circumstances indicating its lack of trustworthiness. So on cross-examination, you can ask questions to establish that it is really untrustworthy. Okay. Now, let's now go to privileged communication. Privileged communication is an interaction between the two parties in which the law recognizes a private, protected relationship. Whatever is communicated between the parties remains confidential and the law cannot force their disclosure. So even disclosure by one of the parties comes with legal limitations. There are, however, exceptions to the rule. And if I were you, focus on the exceptions because this has been heavily amended, no? Okay. Anuhin lang natin, no? Isa-isahin lang natin yung mga privileged communication between husband and wife, between attorney and client, between physician and patient, between priest and penitent, and public officers and public interest. Now, this was also extended and it was enumerated in the case of Eagle Ridge. Editors may not be compelled to disclose the source of published news. Voters may not be compelled to disclose from whom they voted. It also includes trade secrets, information contained in tax census, bank deposits, national security matters, and intelligence informations, and criminal matters. Okay. So when is privileged communication naman actionable? Kasi as a rule, it's not actionable. But there was one case the case of Bilen, no? Communication is absolutely privileged when it is not actionable, so you cannot sue. Now, however, these libelous remarks were contained in a pleading. When you read the original of People versus Bullen, talagang very libelous. Now, that was the reason why, even if technically speaking, okay, it is privilege, but it already went beyond the bounds of decency. A case for libel was filed by the author of the said document against the author of the said document. Okay, marital privilege. Okay, the first privilege communication rule. Okay, spousal privilege is a term used in law to evidence to describe two separate privileges: the communications privilege and the testimonial privilege, which is applied in civil and criminal cases. Both types of privilege are based on policies of encouraging spousal harmony and preventing spouses from having to condemn or be condemned by the other spouse. The spousal communications privilege or confidence privilege is a form of privileged communication that protects the confidential communications between spouses during their marriage from testimonial disclosure. Spousal testimonial privilege is also called spousal incompetency and spousal immunity, protects the individual holding the privilege from being called to testify in the proceedings. Pero yung marital confidence, yung confidence rule, privilege communication rule, nakakaupo sa witness stand, okay, yung asawa. Siguro hindi nag-object. Pero may mga miski siya nakaupo, hindi mo siya pwedeng tanungin sa lahat ng bagay, especially kung yung bagay na yon ay privilege communication. Okay. Now, what are the requisites for the spousal privilege communication rule to apply? There's a valid marital relation. The privilege is invoked with respect to a confidential communication between the spouses during the marriage, and the spouse against whom such evidence is being offered has not given his or her consent to such testimony. Accordingly, the privilege cannot be claimed with respect to communications made prior to the marriage of the spouses. Okay, now. Okay. So the same cannot be invoked when it is not intended to be kept in confidence by the spouse who received the same. Example, dying declaration. Binulong nung asawang lalaki, si Pedro ang pumatay sa akin. Tapos umupo si wife, no, namatay na. She cannot be barred from disclosing who killed because precisely it was told to him by the deceased husband precisely for the wife to be able to share it with others. So you cannot invoke the privilege communication rule in this case because it was intended precisely for the wife to share it with other people. Now, the privilege is lost if the communication is overheard or comes into the hands of third party, whether legally or not. It is necessary that there was no collusion with or voluntary disclosure by either spouse to the third person. Otherwise, the latter becomes an agent of the spouse and would thereby be covered by the prohibition. Okay. I have 1 hour left, so I will make this very fast, no? So in the case of the exception to the marital privilege communication rule is if the offense already directly attacks or directly impairs the relationship of the parties and there is no more harmony to speak of, it cannot be invoked. Attorney-client, okay, let me just focus on the provision. Notice that this attorney-client privilege extends not only to the attorney. It can include an attorney or person reasonably believed by the client to be licensed to practice or engage in the practice of law. Yung kumbaga hindi talaga namang lawyer pero nagpapanggap ng lawyer, kasama din sila. Okay, pangalawa, sino pa pwedeng kasama? Pati yung attorney secretary, stenographer, or clerk, or other person assisting the attorney. Kasama ba yan yung mga nasa student practice rule, for example? The answer is yes. Okay? The answer is yes. Now, there are exceptions to the attorney-client privilege. The first one, if furtherance of crime or fraud, if the services or advice the lawyer was sought or obtained to enable or aid anyone to commit or plan to commit what the client knew or reasonably should have known to be crime or fraud. Or, this is another exception, claimants through the same deceased client as to communication relevant to an issue between parties who claim through the same deceased client, regardless of whether the claims are by testate or intestate, or in cases of breach of duty by a lawyer or client. Dinimanda si lawyer, for example, administratively, the lawyer can of course use that quote-unquote privileged communication naman to defend himself if it's relevant to an issue of breach of duty by the lawyer, or a document attested by the lawyer, okay? Or when it comes to joint clients, okay? Now, the requirements for the disqualification, there's an attorney-client relationship. Privilege is invoked with respect to confidential communication given in the course of professional employment, and the client has not given his consent to the attorney's testimony. Okay. Now, of course, like any other privileged communication, it can be waived. Okay. Now, how about client identity? Well, according to the case of Regala versus Sandigan Bayan, client identity is privileged where there is a strong possibility that exists that in revealing the client's name, the client would be implicated in the very activity for which he sought the lawyer's advice, or where the disclosure would open the client to civil liability, his identity is privileged, or where the government lawyers have no case against an attorney's client unless by revealing the client's name, the said name would furnish the only link that would form the chain of testimony necessary to convict an individual of a crime. The client's name is privileged. Okay. Now, the privilege which protects communications between attorney and client does not extend to a copy of a letter written by the client to his attorney which comes to the hands of the adverse party. Where the authenticity of such document is admitted, the court will take no notice of the manner in which it was obtained. Okay. Okay, so the privileged communication, not confined to verbal or written communication. The privilege must also be for lawful purpose. Okay, let's focus on the privilege, physician-patient privilege. Notice, meron din yung amendments, no? The physician, the psychotherapist, or person reasonably believed by the patient to be authorized to practice medicine or psychotherapy cannot, in a civil case, please take note of that, in a civil case, without the consent of a patient, be examined as to any confidential information made for the purpose of diagnosis or treatment of the patient's physical, mental, or emotional condition, including alcohol or drug addiction between the patient and his or her physician or psychotherapist. And this privilege applies to persons, including members of the patient's family who have participated in the diagnosis or treatment of the patient under the direction of the physician or psychotherapist. And a psychotherapist is a person licensed to practice medicine engaged in the diagnosis or treatment of a mental or emotional condition, or a person licensed as a psychologist by the government while similarly engaged. Okay. Now, priest penitent. Okay, ang gusto ko lang i-focus dito, okay, the advice is not limited to it is not only it not only involves penitential character, no? Why? Because if you read the provision, be examined as any to any communication or confession made or any advice given by him in his professional character in the course of discipline enjoined by the church to which the minister or priest belongs. The other privileged communication will be your state secrets, okay? Okay, and this would apply if it was made to a public officer in official confidence, and public interest would suffer by the disclosure of such communication as in the case of state secrets. So if there is no public interest that will be prejudiced, then this provision will not apply. Now, what is the executive privilege? The executive privilege is the power of the executive branch of government to withhold information from the public, the courts, and Congress. And the president and those who assist him must be free to explore alternatives in the process of shaping policies and making decisions, and to do so in a way most would be unwilling to express except privately. Now, there are two kinds of executive privilege. First is the privileged communication privilege, presidential communication privilege, and the deliberative process privilege. When you speak of presidential communication privilege, it pertains to communications, documents, or other materials that reflect presidential decision-making and deliberations, and that which the president should remain confidential. Deliberative process privilege includes advisory opinions, recommendations, and deliberations comprising part of a process by which government decisions and policies are formulated. And what's the rationale for making privileged communication privilege? Okay. Because of the expectation that the president can have this confidentiality of his conversation and correspondences. Okay. Now, what are the elements of presidential communication privilege? These are essential. The protected communication must relate to a quintessential or essential non-delegable power. And the second is that the communication must be authored or solicited and received by a close advisor of the president or the president himself, operational proximity test. So the general rule, an advisor must be in operational proximity of the president. So the presidential confidential privilege remains a qualified privilege that may be overcome by a showing adequate of need such that information sought likely contains important evidence by the unavailability of the information. And what will be the exception to the presidential communication privilege if there is an adequate need and unavailability? Okay, ano naman po yung tinatawag nating deliberative process privilege? Okay, deliberative process privilege is one kind of privileged communication which is within the exceptions of the constitutional right to information. Okay, court deliberations are traditionally recognized as privileged communications. Okay, that's an example of the deliberative process privilege. Okay. Now, requirements for the invocation of deliberative process privilege to be invoked, it must be pre-decisional. It's antecedent to the adoption of an agency policy. Second, that the communication must be deliberative. That is a direct part of the deliberative process. It makes recommendations or expressions, opinions or local or policy matters. So pre-decisional, it precedes in temporal sequence a decision to which it relates, made an attempt to make a final decision. And deliberative, whether disclosure of the information would to discourage candid discussion among the agency. State secrets, another example of another example of privileged communication. Judicial privilege. Court deliberations, as a rule, talagang privileged communication. Okay, now, confidential information privilege is also a limitation. Okay. Diplomatic relations have been recognized also as privilege in our jurisdiction. Then, of course, you have the parental and filial privilege rule. No person may be compelled to testify against his parents, other direct ascendants, children, or other direct descendants, except when such testimony is indispensable in a crime against a person or by one parent against the other. Okay, you have also the newsman's privilege rule. You have trade secrets, okay? And of course, there are provisions in RA 9285, which is your Alternative Dispute Resolution Act of 2004. Following information obtained through mediation shall be subject to the following principle. Information obtained through mediation shall be privileged and confidential. In fact, confidential information shall not be subject to discovery and shall not be admissible in any adversarial proceeding, whether judicial or quasi-judicial. However, evidence or information that is otherwise admissible or subject to discovery does not become inadmissible or protected from discovery solely by reason of its use in a mediation. Okay? In fact, you cannot even call the mediator, okay, like in letter F, to the witness stand to make him testify as to what were the matters that were discussed. Okay? Now, a privileged communication from confidentiality of information may be waived, recorded, or orally during a proceeding by the mediator and a mediation party. Okay. Okay. Okay, let's now go to admission. Just give me a minute. Okay. An admission is any statement of fact made by a party against his interest or unfavorable to the conclusion for which he contends, or is inconsistent with the facts alleged by him. Admissions may be verbal, written, express, or tacit, judicial, or extrajudicial. Okay, let me just focus on admission by conduct. Okay, flight, example from justice, is an admission of conduct and circumstantial evidence of consciousness of guilt. Attempt to suppress evidence, okay, is admissible too. Now, judicial and extrajudicial admissions, judicial admission, one made in the course of judicial proceedings, and extrajudicial admissions are those made out of court. Okay. Let me focus lang on the differences between an admission and confession. Ang admission, it's a statement of fact which does not involve an acknowledgement of guilt or liability. An admission can be, I was at the scene of the crime. I'm admitting that, but it doesn't mean that I'm guilty. Whereas a confession, it involves an acknowledgement of guilt or liability. Ako ang pumatay kay Pedro. That's a confession. Now, admission can be expressed or tacit, but confession is always expressed. Admission may be made by third persons and in certain cases admissible against a party. Whereas confessions may be made only by the party himself and in some instances admissible against co-accused. Admission need not be made against proprietary or pecuniary interests of the party. It enhances its probative value if it is. Whereas declaration against interest naman, no? If you compare that with admission, declaration against interest must have been made against the proprietary or pecuniary interest of the party. Now, admission is different from declaration against interest in such a way that it's made by the party himself and is primary evidence and competent. May utang ako kay Pedro. Yan ina-admit ko. Okay? Primary yan. Okay? Primary evidence and competent kasi sinabi ko, it is an admission against proprietary interest. Whereas it's a declaration of interest made by a person who is either dead already or as unable to testify. Admissions may be made anytime. Declaration against interest must be made ante litem motam. Okay. Meron ba tayong tinatawag na admission by silence? Yes. An act or declaration made in the presence and within the hearing or observation of party who does or says nothing when the act or declaration is such as would naturally call for an action or comment if not true, or when proper and possible for him or her may be given as evidence against him. And what are the requisites? He must have heard or observed the act or declaration of the person. He must have the opportunity to deny it. He must have understood it. He must have an interest to the object and that such that he would naturally have done so if the statement was not true. The facts were within his knowledge and the facts admitted or the inference to be drawn from his silence is material to the issue. Of course, it does not apply when you talk about a person being quiet while he is when he is under custodial investigation. Remember, he has the constitutional right to remain silent. No? Now, okay. Compromises, ano ba ang general rule when it comes to compromise? Okay? Pag compromise in civil cases is not an admission of any liability, it is not admissible in evidence against the offeror. Okay? Now, when the party making the offer admits being indebted, okay, the offer to compromise is admissible as evidence of liability even if made to buy peace and litigation. Now, pagdating sa criminal case, iba, no? In criminal cases, as a general rule, an offer to compromise is an implied admission of guilt. So the accused may, however, be permitted to prove that such offer was not made under the consciousness of guilt, but merely to avoid the risk of criminal action against him. U.S. versus Mackey. A plea of guilty later withdrawn or an accepted offer of plea of guilty to a lesser offense is not admissible in evidence against the accused who made the plea or offer. An offer to pay for actual payment for hospital, medical, or other expenses by reason of the victim's injury is not admissible to prove civil or criminal liability. Okay, rape can be compromised by actual marriage, okay, and criminal liability is thereby extinguished. An offer to compromise for monetary consideration and not to marry the guilty, yan ang implied admission of guilt. Now, the attempt of the parents of the accused to settle the case with the complainant was considered an implied admission of the guilt. But it will not be an implied admission of the guilt if the parents, for example, tried to settle the case without the consent of the accused. Okay? Now, res inter alios acta. What's the rule? Let me just skip the provisions. Okay, let me discuss the rule. Every act or omission results to a corresponding consequences, which may be beneficial or harmful. Okay? So the rule answers the question, who are bound by an admission and who must bear the adverse consequences? The first part embodies the so-called res inter alios acta alteri nocere non-debit rule. Things done between strangers ought not to injure those who are not parties to it. Or transactions between two persons, okay, ought not to operate to the prejudice of third persons. The effects and consequences of an act or omission should be the sole responsibility of the actor himself and should not affect third person who did not participate in the said action. A man's life, right, and fortune and property should not be affected but by what other people's conduct. Okay. Now, what are the exceptions, okay, to this general rule? Number one is in case of vicarious admissions. And secondly, under the principle of admission by adoption. Okay, let's talk about vicarious admissions. Okay. These are admissions by one who, by virtue of a legal relationship with another, may be considered as acting for or in behalf of the latter. Yan ang vicarious. Okay. These are acts or omissions, declarations of a person who is not privy to a pending case, but are, however, as evidence against of the parties. Their admissibility as evidence is based on the identity of the interest between the stranger and the party is concerned. Ano bang example ng isang vicarious admission? Admission by co-partner or agent. The act or declaration of a partner or agent authorized by the party to make a statement concerning the subject matter or within the scope of his authority and during the existence of the partnership or agency may be given evidence against such party after the partnership or agency is shown by evidence other than the such act or declaration. And the same rule applies to the act or declaration of a joint owner, debtor, joint debtor, or other person jointly interested with the party. So the rule as to co-partners it's based on the identity of interest among the partners, such that each partner is an agent of the other partners. And the existence must first be established by evidence other than the act or omission. So what will be your best proof? Articles of partnership, articles of acts of the partners, contract of partnership, and by principle of estoppel. The second requisite is that the act or declaration must refer to a matter within the scope of the authority of the partners or that it relates to the partnership, such as obtaining a credit and loan, execution of promissory contract, statement as to the financial capacity of the company, declarations as to ownership of partners or properties interests. And it was made during the existence of the partnership. Okay. So you have also agent, rule as to agent and principal. Joint owners also. And now we focus on admission by conspirator. The act declaration of a conspirator in furtherance of the conspiracy, that's the operative phrase, in furtherance of the conspiracy, and during the existence of the controversy, may be given in evidence against a co-conspirator after the conspiracy is shown by evidence other than such act or declaration. Okay. The conspiracy has reference to a conspiracy as a mode of or manner of committing a crime, which presupposes that the crime has actually been committed by two or more persons, and the issue is whether these two or more persons may be held equally guilty. Prove the conspiracy first, and then the act of one becomes the act of all. Hindi ka magkakaroon ng vicarious liability dito kung hindi mo mapuprove yung conspiracy other than the declaration itself. It has to be through other pieces of evidence. And the conspiracy includes both the anterior conspiracy and the spontaneous or instantaneous conspiracy. Okay. Now, the act or declaration referred to those made extrajudicially and not to acts or declaration by a conspirator during the trial, because that can be subject to cross-examination. So what are the requirements? Okay. The existence of the conspiracy among the accused must first be established, maybe direct proof or circumstantial evidence showing unity of intention or purpose and unity of action. And the act or declaration may be presented first to the rule on conditional admissibility. Hindi mo pa kasi napoprove yung existence of conspiracy. So, yung kung ano muna yung sinabi, pwede yun, conditional admissibility. But because it is conditional, you have to prove talaga the conspiracy. Because otherwise, that will not be admitted in evidence. The act or declaration must relate to the conspiracy or common objective. The participation of each in the commission of the crime, the manner of achieving the objective, defenses to be made or relating to the escape, ensuing successful execution of the plan. Okay, now. The other is the rule applies to conspiracy by adoption. And what is conspiracy by adoption? When one joins conspiracy after its formation and he actively participates in it, he adopts the previous acts and declaration of his fellow conspirators which are admissible against him. Then, of course, you have admission by previous. When one title derives title to the property from the other, the latter's act, okay, so Pedro Juan. Si Pedro yung kinuhanan ng title, no? Now, Pedro's act, si Pedro ang kinuhanan ng title. Pedro's act, declaration, or admission in relation to the property is evidence against the former, while the latter was holding the title. So if Pedro is no longer holding the title, kung ano man ang sinabi niya, cannot be used as evidence against one. He must be holding the title when he made said act, declaration, or omission. Okay. So the present owner of a property acquires the property subject to the same burdens, obligations, liabilities, or conditions which could have been enforced against the previous owner. Okay, now, res inter alios acta rule. As a general rule, the extrajudicial declaration of an accused, although deliberately made, is not admissible and does not have probative value against his co-accused. It is merely hearsay as far as the other accused are concerned. Okay? So the extrajudicial confession of a confessant, as a rule, is binding only upon the confessant and not admissible against his co-accused. Okay, that is the general rule. Now, as I said, there are exceptions to the res inter alios acta rule, partner's admission agent, co-conspirator statement, okay? Okay. And admission by previous. Now, confession, okay, the declaration of an accused acknowledging his or her guilt of the offense, charge, or any offense necessarily included therein may be given in evidence against him. And at this point in time, it's very, very important for you to recall, you know, your constitutional law and crime pro teachings in relation to a valid confession. Because a valid confession is a categorical acknowledgement of guilt made by the accused in a criminal case without any exculpatory statement or explanation. If the accused admits having committed the act in question but alleges justification, the same is merely an admission. Okay. Is there a required form of confession? It can be oral or in writing. It need not be under oath. Requisites for its admissibility. The confession must involve an express and acknowledged and a categorical admission of guilt. The facts admitted must be constitutive of a criminal offense. The confession must have been voluntarily made. The confession must have been intelligently made. The accused realizing the importance or legal significance of the act. And of course, there should be no violation of Section 12, Article 3 of the Constitution. Okay. Under RA 7438, Section 2D, any extrajudicial confession made by the person arrested, detained, or under custodial investigation shall be in writing and signed by any such person in the presence of his counsel or in the latter's absence upon a valid waiver, and in the presence of any of the parents, elder brothers and sisters, his spouse, the municipal mayor, the municipal judge, district school supervisor, or priest or minister of the gospel as chosen by him. Otherwise, such extrajudicial confession shall be inadmissible as evidence in any proceeding. That is Section 2 of RA 7438. Okay. Now, also don't forget the rule against self-incrimination. Okay, but the rule against self-incrimination applies only to testimonial compulsion or furnishing evidence by any other means of any fact which the accused has the right to keep secret. It does not apply to purely mechanical acts. And of course, their exception is your immunity statute. No? Now, of course, you know what a custodial investigation is, questioning initiated by a law officer after a person has been taken into custody or deprived of freedom, which includes also invitations to an investigation. Okay, don't forget the concept of fruit of the poisonous tree. Evidence obtained in violation of the right of a person against unreasonable searches and seizures are inadmissible. It refers to an object. It does not refer to testimonial evidence. It does not refer to testimony or confessions obtained illegally. But of course, the failure of the accused to invoke the privilege after the incrimination question is asked before will be deemed a waiver. Okay, let me proceed to similar conduct. Now, I would like to discuss hearsay evidence, which I think is very important. No? Hearsay is a statement other than one made by the declarant while testifying at a trial or hearing, offered to prove the truth of the fact asserted therein. So a statement is an oral or written assertion. So hearsay is applicable to both testimonial or documentary evidence. A nonverbal conduct of a person if it's intended by him or her as an assertion. Hearsay is inadmissible except as otherwise provided by the rules. A statement is not hearsay if the declarant testifies at a trial or hearing and is subject to cross-examination concerning the statement, and the statement is inconsistent with the declarant's testimony and was given under oath to the penalty of perjury at a trial or proceeding or in disposition. Consistent with the declarant's testimony and is offered to rebut an express or implied charge against the declarant of recent fabrication or improper influence or motive or identification of a person made after perceiving him or her. Now, the Supreme Court Subcommittee opined that the current rule, the previous rule, the old rule, a witness can testify only to those facts which he knows of his own personal knowledge, that is, which he derived from his perception, except as otherwise provided in the rules, does not really define hearsay. And that clear definition of the word is called for. Okay? Now, what is the difference between hearsay rule and the rule requiring first-hand knowledge? Okay, and this I base from the notes of the subcommittee. No, this is the rule that a witness qualified to testify to a fact susceptible of observation only it appears that he had reasonable opportunity to observe the fact. So, if a witness testified that on a certain date, flight 450 arrived at the airport at X on time, and from his other evidence, it appears that he was not in that airport at that time in question, and hence could have only been spoken from conjecture or report of other person, the proper objection is not hearsay. Wala siya doon eh. Wala siya doon. Hindi, sinabi niya na wala siyang basihan. Okay? Wala siya doon, hindi niya alam anong oras dumating, hindi man lang niya nakita dumating. The proper objection is not hearsay. The proper objection is want of personal knowledge. Conversely, if the witness testified that his brother told him that he came on the flight and it arrived on time, the objection for want of personal knowledge of when the plane arrived is inappropriate. Kasi may taong nagsabi sa kanya na itong aeroplano dumating ng ganitong oras. So hindi yan want of personal knowledge because sinabi sa kanya. Because the witness purports to speak from his own personal knowledge only of what his brother told him. As to this, he presumably has knowledge. So if the testimony in this latter case was offered to show the time of the plane's arrival, the appropriate objection, therefore, is hearsay. Hindi want of personal knowledge. Dahil inamin naman niya, sinabi niya sa akin, pero ang offer is to prove that the plane arrived at 5 o'clock. But he was not there. He did not see it. But he relied on what was merely told to him. Then the proper objection is hearsay. So the distinction is one in the form of the testimony. Whether the witness purports to give the facts directly upon his own credit, although it may appear later that he was speaking only on the faith of the report from the others, or whether he purports to give an account of what another has told him, and this is offered to evidence the truth of another person's report. However, if it appears either from the phrasing of his testimony or from other sources that the witness is testifying on the basis of reports from others, though he does not testify to their statements and the distinction loses much of its significance, the court may just simply label it as hearsay. Okay. Hearsay evidence is excluded by the rules because the party against whom the evidence is presented is deprived of his right and an opportunity to cross-examine the person to whom the statements or writings are attributed. And as I said, hearsay evidence applies to both oral and documentary evidence. Okay. At ano ang essential prerequisite for accepting testimonial evidence? The personal knowledge of a witness is a substantive prerequisite for accepting testimonial evidence that establishes the truth of a disputed fact. And hearsay evidence, if you fail to object, nakalusot, has still no probative value. Okay. Now, statements which can be made by a witness in which the facts in issue may be inferred without violating hearsay rule. State of the mind, mental condition, belief, intention, ill will, and other exemption. Okay. Now, okay, what are the exceptions to the hearsay rule? Let's just go over the enumeration. I will no longer discuss them one by one so that I can go to the point of documentary evidence. No, I'm sorry, on public and private documents. Exceptions to the hearsay rule, you have your dying declaration, declaration against interest, acts or declaration about pedigree, family reputation or tradition against regarding pedigree, common reputation, res gestae, entries in the course of business, entries in the official records, commercial list, and the like, learned treatise, testimony, or deposition at a former proceeding. But let me just discuss a case of Kendrick development, no? And this is the concept of adaptive admission. A party may, by his words or conduct, voluntarily adopt or ratify another's statement. May sinabi isang tao, but by his own conduct, he is adopting what the other person says. When it appears that the party clearly and ambiguously assented to or adopted the statements of another, that's evidence of those statements is admissible even as to him. This is the essence of the principle of adaptive admission. So an adaptive admission is a party's reaction to a statement or action by another person when it is reasonable to treat that the party's reaction is an admission of something stated or implied by another person. So by adaptive admission, a third party statement becomes the admission of the party embracing or espousing it. Adaptive admission may occur when a party expressly agrees or concurs with the oral statement, hears the statement and later on essentially repeats it, utters an acceptance or builds upon the assertion of the other, replies by way of rebuttal some specific points raised by the other, reads and signs a written statement made by the other. Okay, as I said, I will not discuss the exceptions to the hearsay rule anymore one by one. Okay. Just a minute, please. Sir, what time is it? Time check, please.
Time check, Dean, is 4:37.
Okay, until what time am I given? Okay. Okay, let me just discuss this one case, PNOC Shipping versus CA, which is actually an example. This was not considered an exception to the hearsay rule. Remember, commercial list is an exception to the hearsay rule. Okay, that's an exception to the hearsay rule. 445. Okay, wait. Okay. Now, in this particular case, okay, what was submitted by way of exception to the hearsay rule are price quotations. Anong sabi ng Supreme Court? Price quotations they were not admitted as exception to the hearsay rule. It is true that one of the exceptions to the hearsay rule pertains to commercial list and the like. Okay? In this respect, the Court of Appeals considered private respondents' exhibit as commercial list. It added, however, that this exhibit should be admitted in evidence until such time the Supreme Court categorically rules on the admissibility or inadmissibility of this class of evidence. Because the reception of this documentary exhibits the price quotations as evidence rests on the sound discretion of the trial court. Okay. A document is commercial list if, according to the Supreme Court, number one, it is a statement of matters or interests to persons engaged in an occupation. Number two, the statement is contained in a list, registered periodical, or other published compilations. Third, the compilation is published for the use of persons engaged in that occupation. And number four, it is generally used and relied upon by the persons in the same occupation. And that's the reason why it cannot be considered as a commercial list. Why? Because the price quotations are not considered, okay, commercial lists because they are not published in the list or register or periodical or any compilation on the relevant subject matter. Neither are they market reports or quotations within the purview of commercial lists. They are not standard handbooks or periodicals containing data of everyday professional need and relied upon in the work or occupation. Okay. Now, I would also like to discuss learned treaties. No? Now, there is one case, and this is the case of Pahe versus Casino. Now, in the case of Pahe versus Casino, somebody testified, no? This is about the Bataan nuclear plant, I think. It's a coal plant, okay? And then they were opposing that coal plant. And they attached to their petition, internet source articles, no? And then there's this person who started testifying, and he referred to these articles culled from the internet. Ano ang sabi ng Supreme Court dito? The alleged scientific studies mentioned in the petition cannot be classified as learned treatises. Petitioners cited various scientific studies or articles and websites culled from the internet. However, the said scientific studies and articles, including the alleged key observations and recommendation on the EIS of the proposed RPE project by Rex Victor Cruz attached to the petition, were not testified to by an expert and are basically hearsay in nature and cannot be given probative value. So the article purportedly written by Cruz was not even signed by the author, which fact was confirmed by Palatina, the witness. Petitioner's witness Lakbayan admitted that he did not even personally conduct any study on the environmental or health effects of the coal-fired power plant, but only attended seminars, conferences to climate change. And that the scientific studies mentioned in the penultimate whereas clause of the Sangguniang Panlalawigan of Zambales is based on what he read on the internet, seminars he attended, and what he heard from the unnamed experts in the field of environmental protection. Okay. Let me just discuss this sexual abuse child rule, no? This sexual abuse child rule, what is admissible here in any criminal proceeding involving alleged child sexual abuse, evidence offered to prove that the alleged victim engaged in other sexual behavior, and evidence offered to prove the sexual predisposition of the alleged victim. So inadmissible yan in a criminal case involving alleged child sexual abuse. But there is an exception. Evidence of specific instances of sexual behavior by the alleged victim to prove that a person other than the accused was the source of the semen injury or other physical evidence shall be admissible. And a party intending to offer such evidence must file a written motion at least 15 days before the trial, specifically describing the evidence and stating the purpose for which it was offered. unless for good cause requires a different time for the hearing of for filing or permitting filing during the trial, and serve the motion to all the parties concerned at least 3 days before the hearing of the motion. Okay. And then, of course, you have the residual exception. Okay. Nagkaroon tayo ng listahan ng maraming exception sa hearsay rule. Tapos may residual exception. Ito yung catch-all na tinatawag. And what is this residual exception rule? Because this is a new provision. No? A statement not specifically covered by any of the foregoing exception having equivalent circumstantial guarantees of trustworthiness is admissible if the court determines that the statement is offered as evidence of a material fact, the statement has more probative on the point for which it is offered than any other evidence which the proponent can procure through reasonable efforts, and the general purposes of these rules and the interest of justice will best be served by admission of the statement into evidence. However, a statement may not be admitted under this exception unless the proponent makes known to the party sufficiently in advance of the hearing or by the pre-trial stage in the case of a trial of the main case to provide the adverse party with fair opportunity to prepare to meet the proponent's intention to offer the statement and the particulars of it, including the name and address of the declarant. Okay, and the best example here is, of course, the case of Dallas County, which is a foreign case. No? Okay. Now, opinion rule, I think you can, general rule is you cannot give an opinion and the opinion will not be admissible in evidence. Of course, there is an exception to the opinion rule in case of expert opinions given by an expert or in case of lay opinions on certain specific matters. Okay. DNA testing, I would like to focus when it comes to DNA testing, the case of Herrera versus Alba. DNA analysis that excludes the putative father from the paternity should be conclusive proof of non-paternity. If the value of the W is less than 99.9%, the results of the DNA analysis should be considered as corroborative evidence. Now, if the value of the W is 99.9% higher, then there is a refutable presumption of paternity. Walang conclusive proof of paternity. Merong conclusive proof of non-paternity. And the Vallejo guidelines tell us how do you now question it if you want to question, or how do you establish it? No, you have to show evidence as to how the samples were collected, how they were handled, the possibility of contamination of the samples, the procedure followed in analyzing the samples, whether the proper standards and procedures were followed in conducting the test, and the qualification of the analyst who conducted the samples. Okay. I will likewise skip burden and proof of evidence. Okay. Now, let me just discuss lang direct examination. Direct examination is the examination in chief of a witness by the party presenting him or her on the facts relevant to the issue. Now, cross-examination, we follow the British rule. No? Upon the termination of the direct examination, the witness may be cross-examined by any parties on any relevant matter with sufficient fullness and freedom to test his accuracy and truthfulness, and freedom from bias or interest or bias or the reverse, and to elicit all important facts bearing upon the issue. Okay, leading questions not allowed. Leading questions may be allowed on cross-examination, preliminary matters when there's difficulty in getting direct and intelligible answers from a witness who is ignorant or a child of tender years or is of feeble mind or deaf mute, or of an unwilling or hostile witness, or of a witness who is an adverse party or an officer, director, or managing agent of public or private corporation, or of a partnership or association. Okay. Now, please take note when you study your testimonial evidence, please do not forget, and I would like to stress it, do not forget the judicial affidavit rule. Okay. Now, the judicial affidavit rule is the rule, okay? Meaning to say the direct examination should be reduced in judicial affidavit form. But in AM number 15-06-10 SC, under the revised guidelines for continuous trial of criminal cases, there are instances when the judicial affidavit rule, okay, are not required, okay? Please take note of that. Okay? Cross. Okay. Ang gusto ko lang before I end, no? I would like to focus on authentication and proof of documents. Okay. Now, there are two classes of documents. You have the public documents and then, of course, which are referred to as official documents. There are documents it's a document for a document to be public, it must be an official written act of a public officer. Now, a foreign decision purporting to be the written record of an act of an official body or tribunal of a public country, of a foreign country, is a public writing, not necessarily a public document. No? Now, there's a difference between public document and private documents. And please take note of this. Public documents generally are admissible in evidence without further proof of its genuineness and due execution, except where a special rule of law requires proof thereof despite it being a document acknowledged. Example, probate of the will, of a notarial will. Even if the notarial will has been duly executed and notarized, you still have to prove the due execution and authenticity thereof. Private documents are not self-authenticating, so it must be proved relative to its genuineness and due execution before it may be received in evidence. Public documents binds and can be used in evidence even against third persons of the fact which gave rise to its due execution and to the date of the latter, whereas private documents binds only the parties who executed it or their previous insofar as the due execution and the date of the document is concerned. Okay. Authentication of a document is not required when the writing is an ancient document, when the writing is a public document or record, when it is a notarial document acknowledged, proven, certified in accordance with Section 30. Okay, but please take note, ibang rule pagka notarial wills, no? And of course, when the authenticity and due execution of the document has been document has been expressly and impliedly admitted by failure to deny the same under oath. Okay. I think, just a minute, please. Okay. With that, I think we can end there. Last na lang, offer of evidence, no? Now, pag you talk about kailan ba ino-offer? Ino-offer ang testimonial evidence before you make the witness testify, no? So that's the reason why you say the testimony of the witness is being offered to prove the following. How about documentary evidence? When you speak of documentary evidence, in the course of the trial, okay, you identify and you authenticate. That is not offered yet. After you have presented all your testimonial evidence, you now make a formal offer of documentary evidence. You state the purpose and the other party is given an opportunity, okay, to comment or object to your proposed formal offer of evidence. So the procedure's formal offer, you object. If it's sustained, evidence offered will not be allowed to be presented in court. If it's overruled, evidence will be allowed to be presented in court. Now, what is your remedy if the objection sustained? Remedy is to do a tender of excluded evidence, and if it's overruled, you continue with the presentation of evidence. Okay, and as a rule, okay, a document that was not formally offered should not be considered, okay? Unless, of course, okay, sometimes if you forgot to do your formal offer of evidence, but if the evidence already forms part of the records of the case, it may be considered by the court, okay? Okay. I think with that, and given that weight and sufficiency, I can leave that with you already. So before I end, and I always say this, and I would like to first congratulate you already, because you have, in a matter of days, in a matter of weeks, your dream to become a lawyer is just within your reach. You continue praying, because as I said before, and I will repeat it again, the formula for passing the bar is study as if you've never studied before and pray as if everything depended on God. So it is my sincerest prayer to see you when you take your oath as a lawyer this December. Okay? So thank you very much for staying with us. And again, God bless you all. Thank you.
All right. Thank you very much, Dean, for the very comprehensive lecture. It was very insightful and clear. And we truly appreciate it, Dean, for covering all the salient aspects and explaining some jurisprudence on the topic evidence. Now, to all the viewers, we are now encouraging you to please comment down your questions on our Facebook Live so our speaker can answer all of it. So while waiting for that, a gentle reminder again to everyone that this video lecture series are being streamed live on the official Facebook pages of PALS and Rex Bookstore. The reproduction and recording of this session are strictly prohibited because all the pre-week lecture series are available and can be replayed on the official Facebook pages of PALS and Rex Bookstore. So now, Dean, while waiting for the questions po nung viewers, I just have a question also prepared, no? So, Dean, online live selling is now one of the marketing tools of the online businesses, such doing it on Facebook, TikTok, and other social media platforms. And one way of securing the sale of a thing, so therein the buyer needs to comment mine and some code that was being mentioned by the seller on the comment section of the live selling. Now, the seller will take a screenshot of the comment of mine, of the said buyer. So, may we ask, Dean, as to the evidence admissibility, best evidence po ba yung magiging screenshot of the mine in this kind of cases, and will the court deem it admissible po?
Okay, I think this will be considered okay. The best, when I use the word the best evidence, the evidence that will show that there was the meeting of the minds, that there was indeed a sale, will be of course the offer and the agreement. Pag sinabi mo, as I understood it from you, sir, when you say mind, that means you have already gave your assent to buy, no? So there's
That's right
already
po.
a meeting of the minds. So what will be when I say best evidence, the evidence to show, yun na lang siguro, what will be the evidence to show that there was a consummated sale, in the sense that there was an offer and there was an acceptance of the offer, okay, will be that those documents that you say they were the offer and then the mind. Pwede yun, pwede mo yung i-print, and that will be the best evidence.
All right, thank you, Dean. One more last question could be, can the admission of an accused during his media interview be the basis of his conviction?
Sir, it depends.
Okay.
If during the media, if the reporter acted on his own without the influence, okay, or he did not conspire with the policeman, on his own, nag-interview, then when he interviews this person and the person now says, yes, I killed this person, technically he already confessed. Okay. Do you need the reading of his constitutional rights? No, because the person who's interviewing him is a media practitioner. Okay. But if the media practitioner did it, okay, to assist the police or was under the instructions of the police, interviewin mo yan. Okay. I don't think it's going to be admissible because this time it's the police, and the police should have informed the accused of his constitutional rights.
Okay. Thank you very much, Dean, for answering those.
Yeah,
Yes,
so sa mga nanunood, tuloy-tuloy lang ang laban, you know. Now is the time to face the battle head on and with high heads, no? I'm very sure you're very well prepared. Go on, slay the bar, and be the best lawyer you can be. Okay? Thank you.
All right. Yeah.
Salamat.
Dean, last final remarks that you can provide to our barristers who are currently watching po.
Okay, when I took my own bar the night before the bar, I was very, very scared. In fact, I couldn't even sleep because I was very scared. But then I realized you know that fear is the very vitamin I needed to to wake me up, to make me to make me feel so driven and to be in a fighting mood. So even if you're scared, you know, the fear becomes your vitamin, no? Vitamin to be what? To be hungry, to be driven, to wake up in the morning and have a purposeful life. So it's okay to have that fear. But please conquer your fear. Okay? Because when you go to the bar, it's mind over that fear. Okay. And you are prepared. Naku, nag-aral kayo ng 4 na taon. Yung iba nag-aral pa ng 5 taon. Tapos nag-review na. Sobrang pag-aaral yan. Maniwala tayo sa ating kakayanan. And of course, pray. Very important to pray. Okay. So as I said, chill lang, chill. That's the best, no? Chill and you'll be okay. Okay.
All right, Dean. Thank you very much
Thank you
again
very
for
much,
all the
everybody.
knowledge and wisdom that you have imparted to all of us today. I'm sure that all our barristers and other who have watched this lecture and through the questions and answers that we had po, no, have learned a lot from it. So we appreciate and grateful to you, Dean. Maraming salamat po ulit. All
Yes.
right.
Thank you, sir. Bye-bye.
All right, everyone, Rex Education would like to invite everybody to visit them tomorrow, September 14 until 17, Sunday, during the Manila International Book Fair at SMX Convention Center, Pasay City. So they are open from 10 a.m. to 8 p.m. There will be big sale on law books, and you may also join their promo and get a chance to win exciting limited prizes. So please visit their official Facebook page, Rex Education, for further information. So see you there.
See you. Bye-bye.
Okay. Yep. Now we have come to an end of the 2023 Pulse Bar Operations pre-week lecture series. Thank you very much to all those who have attended and watched all the pre-week lecture series. To all the barristers, have faith in yourself and to God. And as what Dean Mawis told us, conquer that fear. We are all rooting for you, and you got this. Again, ladies and gentlemen, this has been the 2023 Pulse Bar Ops pre-week lecture series, the frequently asked topics on the 8 bar subjects. I'm Kyle Roger again. Thank you and have a great day.